which side should we win? This side or that side? Well, that's because our position is that in some situations that
There should be a group of companies doctrine.
yes, we should have, but there are limitations to that, which we would like to place before your lordship. So where should we,
But now we know where, what you're going to argue, so that's a difficult question, actually.
well, then, may I then address your lordships after Dr. Singhvi?
Yes, after Dr. Singhvi.
Yes.
So that, and you can argue, you can address us on both aspects, why there should be the group of companies doctrine according to you.
Very well.
And then secondly, but it has to be restricted, and then what should be the contours of it?
That's correct. I'll try and do that. I won't take long, half an hour, not more than that, 45 minutes.
I'm also in the same boat as my learned senior, because my submission would also be that we need the group of companies doctrine, but in a more limited form.
Then Tuesday, yeah. Today, my learned brother is right. Apart from today, we have Tuesday. Next week, we have a 3-day week.
Yes.
So the first and the third day will be miscellaneous.
That's right.
That Tuesday, we'll finish the hearing of
Fair enough.
I only require 15 minutes.
So you will have
I'm
to
also in 5-0.
give him sufficient time.
Give enough time to, because Mr.
Yes.
Rai is really the person who's, and the solicitor, I think, is going to be pretty much on this side also.
Yes, yes.
I will go after them.
So then Mr. Rai will have to have sufficient time to discuss.
Fair enough.
Wait, please.
There's no height.
Let me just.
Today I have a bench at 3:30 with Justice.
3:20.
Just that Unitech will wait so we can.
Let me just oralize for 5-7 minutes. Then I have got written submissions. Let me just summarize broadly. Broad sequence and summary, and then I'll take a lot through the submissions. There are now 5 broad heads. One is the recasting into 2 issues, which your lordships covered with me broadly. According to me, your lordships is not, I'm not saying that the reference is bad per se, don't decide the issue, don't touch it. That's not the point. Your lordship should go into it, but in these 2, which are one, that is the act, does the act inhibit your lordships from having a doctrine at all? And 2, otherwise, is it a desirable judicial policy, desirable interpretation, etc., etc. There's a broad 2 heads. I'll read them in a minute, but I'll give you the head. That's one. My second head is, and I think that's a little important. I have tried to do the reverse, analytically cull out from the 10 odd main cases, the basis, the justifications, the juristic principles on which the group doctrine can and should be justified. I have found out 16 broad principles, some overlaps. So that will be useful for your lordships to analyze this way or that way. And I'm happy to underline again and again pointillism. So that is the heart of the matter, in the sense that jurisdically, your lordship has why desirable, what are the reasons, what are the underlying bases, and is it some harebrained idea which has no juristic basis? That's the purpose of these 16 principles. Many of them are culled out from the case law. And I've done the reverse. I put the principle and then put the actual para of the case. Some are not. Some are the way I would like to put it. That's my second head. The third is the extracts from 9-10 judgments, which takes up almost 7-8 pages of my 17-page submissions. Submissions are shorter, but the extracts I put, which adumbrate one or the other of these principles, or don't adumbrate it, but they are my principles, which I am advocating for your lordship's kind consideration and adoption. So this part is the extracts. And lastly, a very brief analysis of the Act to suggest that there is no prohibition explicit, there is no prohibition implied, by any stretch there is no inhibition, forget prohibition. And therefore something which your lordship in the earlier sections has found desirable, good, based on valid principle, absent a implied or an explicit prohibition in the Act, if at all there is a slight encouragement, because that can never be inhibited without some statutory limit or bar. There are five. The first is only the recasting, four broad heads. Now, may I, with that in mind, take your lordships to my submissions. Mostly, my submissions with two volumes, which I have, I think, more aptly called CL1 and CL2. Case law 1 and case law 2. More or less covers everything which I have to say because they cross-reference these two volumes. So my WS, my submissions with CL1 and CL2. Give anything to them.
Title is List of Authority, Volume 1.
Yes.
Just because you give a title doesn't mean our court master accepts that.
No. Because in fact, I was
He
telling.
will have his own.
No. In the other matter, in the other constitution bench, some of this work will
It has been emailed to your lordship, personal email also. At 9:30 in the morning, they were received.
No. In fact, I must say something.
Volume C1 is
I must tell you, lordship, I must in fact commend the court master and the staff for something in 30 seconds. Because in the last constitution bench, which was going for a long time and we had more time, even then some things came in the morning. And some of your lordships' email systems were accessible, others were not. So it had to come in the night in most cases. And the ones which were not, we could not get through. I think your lordships in the earlier commission did and the others. Today, given the nature of the suddenness and our logistic preparation, it is given only at 9:30. But I am told that they have been loaded onto your lordships, which is very, very creditable because there was no way we could do it before that. We made separate hard sets just in case your lordship don't have it.
Not to my.
Right. Now, if your lordship sees the recast at B.1 of my note,
yes.
whether the acceptance, adumbration of the group company's doctrine by the Honorable Supreme Court in several earlier judgments is not permissible within the four corners of the 96 Act, therefore contrary to statute. This would more or less cover the legal issue according to me, without being specific about sections, but 96 Act. Divorce A above, which possibly may not arise, but I am putting it against myself since the lordship in the constitution bench dealing with the subject, your lordship might as well give the larger picture also. That's the only reason I put it. Whether the Honorable Supreme Court should at all have accepted adumbrated the above doctrine as a matter of desirable judicial interpretation and judicial policy. Well, para B.2 tells your lordships that Honorable Chief Justice Ramanna's formulation would be under this. It would fall within these two issues. Well, as Justice Suryakant, well, as 1042, 3 and 4 are really reasons of his judgment, which is my para B.4. And the first one covers and is subsumed under my two issues. I'm just reassuring my lord that nothing is really left out. Now your lordship should come. I'll read the case law later, but just come to the conceptual part. This is the most analytical part. C1 to 16. 16 principles which I have called out. And your lordship will just go slowly here and then we'll read some of the case law later on. May I read this? Summary of principles culled out from existing Indian and foreign jurisprudence, establishing the clear desirability of recognizing and applying the doctrine of group companies and common economic entity in arbitration law. This is my issue B, not my issue A, not the statute. This is issue B. The doctrine constitutes a true and genuine effectuation of the real intent, italics, of parties. Now, actually, these paras use this most liberally of these judgments. Actual paras are given. And there is no reason why the true intent of parties to subject not merely signatories but also related and group entities should not be effectuated. Well, as one batch of cases puts it rightly on the salubrious principle of real intent, true intent. And that is the basic principle. I've given 5 cases, there are more. Second, the doctrine evolved in the context of related entities playing a predominant role both at the negotiation stage, which is at the inception of this, as also in the course of performance of the contract, even though they were not signatories. And I'm asking myself at each stage, what is wrong with this reasoning? What is unjust about this approach? My respectful submission is nothing. It is desirable because it is just, fair and honest, otherwise logical and correct. My third principle. Well, there is an error. That word not has to be deleted. I'm sorry. Last line of C.2.
Yes.
Even though they were non-signatories, not non-signatory. I hope I'm clear. The not will go on. We'll just cut it out. Third principle. Absent such a group company's doctrine, it would allow evasion and avoidance of legitimate collective responsibility arising from the contract and permit injustice. You also see the synergical cumulative impact of all the 16 at the moment reading the numbers. Indeed, to extend the previous point, this is a separate point, it would also facilitate evasion of law through a hyper-technical approach. 5. The group company's doctrine is a reasonable and natural extension of the piercing of the veil doctrine, and some or all of the already established legal tests in corporate law regarding piercing of the veil would, depending on individual facts of individual cases, also arise in favor of the application of the group doctrine. Nonetheless, there is an overlap here. For example, take alter ego. Alter ego has been a lordship test to pierce the veil. It would apply here also. Some will not identical, but this is a further natural extension to arbitration law of what is already an established doctrine in corporate law. 6. Juristically, the group company's doctrine is also fully justifiable when the requisite and sufficient degree of common ownership and control exists. And there is no reason why such persons, entities should be able to avoid legitimate responsibility on the technical plea of non-signature. Collectively. A seventh principle is well as where Lordship finds gross injustice is caused. Your Lordship must apply. Sorry, gross injustice. That's the 7th. Then another comes to implied consent in 8. There is no reason, the doctrine can also be justified on the separate juristic basis of implied consent, a well-known concept in the law of contract and arbitration. 9. There is no reason why the group doctrine should not apply if there is a direct relationship between the parties, which is a signatory to the arbitration agreement. This I am putting from a judgment process. Direct commonality of the subject matter, the composite nature of the transaction between the parties, full stop. A composite transaction refers to a transaction which is interlinked in nature. Then was the next principle, and this is juristic. Gary Bond, an outstanding jurist from the continent, German, who was settled in the common law system, who's written some very good books. The principle is equally justifiable on both purely consensual theories, he says, agency, assumption, assignment, and non-consensual theories, estoppel, alter ego. And this, Your Lordship, has approved this para in Charan from Gary Bond. I believe my Lordship, Charan. It is a vitally useful doctrine to prevent, this is very important, fragmentation of disputes. Kindly note this. And therefore, it is highly desirable for legal and judicial policy. Then, 12. It is of particular relevance contextually in India, a country whose business and commercial structure is more heavily reliant upon traditional forms of family-run businesses, where technical distinctions between signatories and non-signatories would cause grave injustice. Justice Suryakant had a whole paragraph in Cox and Kings read to your lordships yesterday on the family business nature in India. Then 13. The doctrine of purposive or teleological interpretation adopted by courts in diverse situations necessitates the application of the group company doctrine to deal with the core issue at hand and prevent injustice arising from technical avoidance tactics based on formal signature or absence thereof. 14. The alter ego doctrine, already known to corporate law, proceeds on the assumption that two or three entities formally, but this formally is wrongly typed, it is ALLY. Formally. That is ostensibly one. Formally distinct are nothing but de facto alter egos of each other and must necessarily be seen holistically in the process of dispensation of justice. Now, when I come to something which will be relevant in the law also, but actually on the desirability, I've dealt with it here. 15 and 16 are related. So we'll just read 15 and 16. By the 2015 October Amendment to Section 8, by Act 3 of 16, inserting the words any person claiming through or under him, in turn based upon the reasoning of the 2246th Law Commission, my lord saw that yesterday in the judgments I have cited the paragraph. The legislative intent to recognize and codify the pre-existing reality of non-signatories, effectively acting through or under signatories, is statutorily recognized so as to do complete justice. Now I come to what I call a red herring of 2.1h, which also engaged your lordships yesterday. The absence of a corresponding amendment to 2.1h at the same time as Section 8 was amended would be irrelevant to the interpretation of the latter. Firstly, the amendment to Section 8 has to be construed on its own terms, and both the Law Commission report and the words added to Section 8 in 2015 are crystal clear. Secondly, the effect of those words and the intention reflected in the Law Commission report as adopted by Parliament cannot be nullified or diluted by recourse to what might or might not be done in another provision, namely verse 2h. Thirdly, unless the three-judge bench in Chloro is held by the Honourable Constitutional Bench to be erroneous or unsustainable, it is clear, that's important, it is clear that full mind was consciously applied by the Chloro bench to this issue, while contrasting the language of 45 and 8. After contrasting, thereafter the Chloro bench proceeded to read the group doctrine into 45, principally on the basis of the difference in language between 8 and 45. That's paras 94 to 96 of Chloro. Fourthly, if that be so, the subsequent insertion of the same words in 8 by the 15th Amendment must necessarily have the same effect of introducing the group doctrine into 8. Because far from the legislature making any attempt to dilute or overturn Chloro, they were in fact effectuating and endorsing the intent of Chloro Way 45 to another section of the same act, namely 8. Lastly, because fifthly, the latter clear intent of both Chloro and of the legislature in enacting 2015 and indeed of the Law Commission cannot in any manner be diluted or nullified by reference to what could be done or might have been done but was not done in respect of 2h. Such an approach to interpretation to whittle down the true intent of Chloro or the Law Commission and indeed of the amendments would be unjust, unsustainable, and untenable. Whereas these are my 16 principles conceptually, analytically, which is the totality of what I have been able to call out. They show us, A, this is a doctrine based on valid juristic principles, diverse. B, none of these principles are undesirable or need jettisoning by your lordships. I mean, there could be a principle which is most objectionable. None of these are like that. 3, they are mostly backed by existing diverse case law. Almost every principle I have cited the actual para. Therefore, clearly my second issue about the per se desirability and this decides the desirability and the contours. They are the contours. Ultimately, the guidelines are these only. Both must give this doctrine its reasonable full play, unless in my last section, which I am now coming to, your lordship finds the inhibition in the statute. That is it. So, something which your lordship has had for almost 2013 was chloro. So, it was about 10 years, a little more. High courts before that, plus legislation. There has to be a reason to dilute it, change it, overthrow it, in whichever form. One is the extreme overthrow theory, one is the total support theory and more expansion, one is the middle theory that support it but with conditions. All three are subsumed in my section C, unless your lordship finds it anathema. The contours, the principles, the boundaries cannot be and should not be whittled down to more than what is in C. They may not be expanded beyond C, I don't know. A future case for us, common law expands by incremental expansion, slight incremental. But certainly what is existing in these 16 principles, none of them I find so much objectionable in my humble and respectful submission that your lordship's intervention is required. And it is not a stray case, which is now the chloro progeny. Chloro itself had a mother agreement and a progeny set of agreements. But the chloro progeny of judgments are many. And today, unless your lordship finds a fundamental problem of principle, the lordship should actually affirm it with these contours. Now, let me deal with the extracts, which cover, I can read the judgment. I've got the facts of both judgment also marked. Maybe when your lordship asks me anything specific, I'll do that. But normally, your lordship may not need to. That's the advantage of putting it down. And that's why we could give it only at 9:30, because your lordship will have, of course, any facts your lordship want to know, I will certainly go to it anyway.
Dr. Singhvi,
I'm sorry.
while we are at it, you described this leaving out the 2(1)H amendment.
Yes.
Incorporated.
Yes.
And saying that section 8 should be interpreted singly in order to understand what the law commission intended. You have described it as a red herring. Why do you say that?
Yes.
Because we are yet to hear the Solicitor General on why either it is left out deliberately or it is,
No, that was the reason behind the thing my learned friend will have access to. I have not found anything.
No, correct.
He will have
has to say it.
I mean it a different way. My point is not about the reason behind that. My learned friend will enlighten us, and I'd like to enlighten us. The issue in 2(1)H, your lordship, that's coming in my section E, but let me just explain it here. In the light of para 15 and 16. Party means a party to an arbitration agreement.
Yes.
Textually as it is, it does not mean party means a signatory to the agreement. Textually. Facially. Party here, when read not only with 8, but with the general common law which your lordship has adumbrated. In appropriate cases, where justice so demands on my 16 principles, will include the group party. So 2(1)H is not anathema. What I am saying in 15-16 is only that what your lordship finds in the full play of section 8, which is the actual text amendment. I'm not saying I'm arguing, I'm saying in the event it is argued. I've not heard Mr. Rai yet. He may not argue it. In the event it is suggested that your lordship should whittle down the scope and meaning of 8, because 2H was not correspondingly amended. that would be a wrong approach to interpretation. That's the only purpose of my saying. So I'm very grateful for the query. So let me summarize. 1. Common law establishes a group doctrine which your lordships has no particular reason in my humble submission to dilute or nullify. Subject to my lord's decision ultimately. That's my issue B. I've given 16 principles. Second, common law to some extent was inserted into 8. I mean, they don't use the word group doctrine, but to some extent I feel. And it had a law commission, it had a history before of chloro, it had 45 and 8, all that stuff your lordship knows. So second point is that insertion is a recognition by statute of some part, some scope of the group doctrine. Third, question arises that insertion is faulty, incomplete, should be read down by your lordships, whittled down, or reduced to vanishing point, because the legislation never amended correspondingly to 1H. Answer is no from my side. Fourth, why is it no? It is no because firstly 2(1)H itself is consistent with an expanded meaning of a group party where the case arises. It is not to be limited to signatory. Fifth, the second reason why 2(1)H will not be a hindrance to your lordships, if it is so, I don't know which way the direction the argument will go, would not be a hindrance also because 2(1)H your lordship may have amended, may not have. My learned friend will give us the reason why I have not found anything in the Trago Preparatoire. It can't affect the direct legislative intent to insert 45 into 8. So that's the fifth point about interpretation. Your lordship's approach to interpretation should not be, unless compelled to do so, that your lordship whittles down X by reference to non-amendment of Y.
So once section 8 has come in, you interpret section 8 on its own.
I'm very
understanding and
grateful.
words.
Own plus more fortified by 246, Law Commission and chloro. Chloro, that para I read yesterday made a clear distinction. It said 45 has this language. 8 does not. Para 59. 69. And therefore that led the Law Commission also, then led to, whatever the reason, they said, look, the court is appointing on 45, let's have it in 8 also.
The judgment in chloro should not have a chloroform effect.
That appears to be a potential argument which I am in advance preempting. My lord is absolutely right. A chloroforming effect on 8 because of the non-amendment of 2H would be wrong approach to interpretation. My lord is absolutely right. Chloroforming, deadening, stilling or chilling effect should not be there. I am grateful. Now your lordship comes to D. They know it. Some of this was quotation the lordship will see, and these are important. Now, your lordship has a whole development of the law. It is not a one spot of the summer or one of the splash, one drop in the pond. This is a consistent thing. See the way it is developed, and your lordship will see what is objectionable. So, chloro is intention of parties, the test I said, along with commonality of interest to bind non-signatories. All the paras are given there. Then they also put it on implied or specific consent in para 107. Now, some of these I will read, but at the moment I am only reading the extracts. I have chosen only two, otherwise it will become very long. My written subject will become many pages. So I have given you two extracts. This evolves the principle that a non-signatory party could be subjected to arbitration, providing these transactions were with a group of companies.
Oh, yes, para 72. Okay, yes. Yes, thanks. Yeah. Yes.
And there was a clear intention of the parties to bind both the signatory as well as the non-signatory parties. In other words, intention, this is my first principle, true intent. This is my first principle, And that is the correct way. Both contract law and arbitration law, main object is to fulfill this intention of parties. Your Lordship has said it 100 times. Is a very significant feature which must be established before the scope of arbitration can be said to include the signatory as well as the non-signatory parties. A non-signatory or third party could be subjected to arbitration without their prior consent. But this would be only in exceptional cases. Now, why should a Lordship have to change this emphasis or even the contours and guidelines? Kindly pause here, I am saying something different. Your Lordship has laid down a certain law. My Lordship has already cribbed and confined it by such paragraphs. It is not that in every case we just jump up and say group, and a Lordship accepts group. So there is sufficient inbuilt safeguards. The court will examine these exceptions from the touchstone of direct relationship to the party signatory to the arbitration agreement, direct commonality of the subject matter, and the agreement between the parties being a composite transaction. These are some of my guidelines, my 16 guidelines. These are some of the criteria. Now, your Lordship cannot be asked to crib and confine it in a manner that your Lordship is to anticipate all future situations and bring in rigidity and non-flexibility. That's not possible for your Lordship. Commercial matters have very, very different contours every future case. Chair. Well, I had the occasion to appear in Chennai. My Lord heard it. That was a little strange fact. You may not remember this.
It was actually a very strange case, because he had assumed the obligation clearly.
Not only that, I appeared for the losing party whose immediate relation had lost the arbitration award up to the Supreme Court.
Right.
He set up a proxy to challenge the same award all over again. I was waiting for that proxy. Your Lordship found him with a proxy. Your Lordship found him with a proxy. You were denying it's a proxy, but your Lordship found him with a proxy. So that really turns on that. Of course, we were denying it's a proxy. Your Lordship found the matter of fact. And that's how your Lordship pierced the veil. The original award was lost to the Supreme Court. The new fellow started the ladder all over again. So, here, group companies doctrine applied to pierce the veil. Doctrine of companies is akin to principles of agency or implied consent. Now, C, D.2c. In Charan, so the Lordships relied on bond. The doctrine provides that a non-signatory group may be bound by an arbitration agreement where a group of companies exists and the parties have engaged in conduct. This is where the principal comes in, such as negotiation or performance of the relevant contract, or made statements indicating the intention assessed objectively and in good faith that the non-signatory be bound and benefited by the relevant contracts. While the alter ego principle is a rule of law which disregards the effects of incorporation or separate legal personality, in contrast, the group of companies doctrine is means of identifying the intentions of parties and does not disturb the legal personality of the entities in question. So my Lord makes a distinction which is conceptual. In other words, the group companies doctrine is akin to principles of agency or implied consent, whereby the corporate affiliations amongst distinct legal entities provide the foundation for concluding that they were intended to be parties to an agreement, notwithstanding their formal status as non-signatories. I'll just pause here. Take an actual situation, we do it every day on this side of the bar, and a lot of here's many of those fact situations on that side. Whereas foreign companies come in a clutch of different personalities. The holding company is A in USA. Its Asia regional head is B, located somewhere in Asia. Its India company is C. And when a tender is floated, the bid is by an SPV, which is D. My Lord must have had hundreds of cases like that. Now, they are all really, now, in every case, because they are part of a large group, it doesn't pierce the veil and have a group company. Not that I'm saying that. Now, at the documentation at the beginning of the negotiation, and thereafter, more importantly, in the performance, The SPV may be a shell company. Frequently, it outsources or gets it implemented by the previous company C. The negotiation is entirely done by B and C. Now, your lordships may, in an appropriate case, have necessity to say, look, all of these, well, if a dispute starts and I go only against D, it's a Pyrrhic victory for anybody. Whereas if I go against only D and I win an award, it's a Pyrrhic victory in many cases. It's a futile. Equally, it doesn't mean that a lordship straight away goes to A. That's not the argument. But your lordship must have play in the joints, flexibility in the joints to decide. Well, the judges ultimately decide by a feel of the case. According to me, feel of the case is the most important. There, your lordship then goes into details. Now, the feel of the case requires justice to be done. Your lordship is told strictly there is no doctrine, or the doctrine is so circumscribed that you will not go beyond D. That will cause injustice. That is not. And something which is not new. Your lordship has got it 10, 12 years in India and much before that abroad. Why should your lordship crib it, confine it more, or indeed abolish it? That's the question. In this group, your lordships need award not to be Pyrrhic. Well, sometimes they say that the evidence will not be there if you don't have other parties. Sometimes you say that witnesses will not be there if you don't have other parties. That flexibility has to be there. Just to say, one of the arguments is that this group doctrine is only in 2 or 3 countries.
The flip side of
India,
the flip side of flexibility is uncertainty.
No, I'm coming to that. Now, uncertainty. Suppose this same example I've given, the contract makes it clear in 2 crystal clear clauses of great comprehensiveness that the parties from the inception know that this is being negotiated and performed by D, or rather by C, but the SPV is D. And under no circumstances shall there be any liability, any suability, any involvement of C. That will be an important exculpatory circumstance, even there is not binding on a lordship. It will be an important clue to the intention of parties. It's the intention of party the lordship is searching for. That intention may come from a letter. What is referred to as uncertainty is also going to play in the joints.
Suppose the conduct of the parties are such, and yet they have a letter written by the principal, A, that we are nothing to do with this contract. But then they have conducted themselves in a manner which would suggest that they have actively participated.
Exactly.
Then that letter, would that be a defense?
No, that's the point I'm making. It is all in the common hodgepodge of your lordships gleaning the intention. In the common hodgepodge, your lordship finds that everything is done from breach, from performance, from negotiation, from implementation by X. But X has written a letter, look, I'm out. I'm not liable. No. Your lordship will go by the overall conduct of the case. That one letter will not escalate. However, if from the inception there are repeated letters saying that, look, this is the position, we have put not 1 but 2 companies, then it will be one of the clues to intention. Not dispositive. The answer by Lord is not dispositive, not binding. But it will be one of the clues to intention of the parties, which is paramount. Ultimately, the reality, the real point of this doctrine is the reality to do justice has to be seen, not the formality. And your lordships should not, according to me, worry or be anxious about the fact that your lordships can never in any principle anticipate all the myriad cases or situations. Within the existing 16 principles, or any more principle your lordship may add, how is it possible that somebody will get injustice because your lordship has ample principles here?
There is some problems.
Yeah. Chetan. Arbitration.
Because you are wanting an interpretation which is justice-oriented interpretation. Because this is not in the realm of public law. My fundamental problem with this is not in the realm of public law. This is purely a private remedy,
Correct.
purely and absolutely private remedy. Looked at in that context, section 6
Yes.
has to be interpreted. Section 7 has to be interpreted.
Article
To
7 is
mean
next.
an agreement between the parties, coupled with the subsequent sections very specifically saying that there must be a written agreement. Agreement between signatories. So the contract, the required, so the statute in arbitration law as against what we have in a civil court where there is a remedy available to anybody, publicly provided, or compare with 226 or 32. These are public remedies as against a private remedy. So when we talk about a private remedy, it must be strictly an agreement between the parties. And to say an agreement between parties can be parties, open-ended parties. And the court will from time to time, case to case, will decide on the facts of a case, who will be the parties, who will not be the parties, depending upon public requirement and justice between the parties on a larger perspective will create a lot of problems. Because number one, every stage of section 11, you are expecting the court to do an inquiry whether justice requires a party to be brought in or not.
No, let me explain. I'm grateful.
Only consideration so far as contracts are concerned are if it is hit by public policy, yes, of course, courts can
So
intervene.
let me, Malas, I'm very grateful for the query. Let me, Malas, just expand on this. This helps me to clarify. Number one, I am not at all saying that your lordship will or will not apply group doctrine on the basis of justice. Please take that, Malas, as given. I'll put it, lordship will note it down in my submission. That's not at all. And that would be too wide, too open-ended, and it would be actually causative of injustice. What am I saying? I'm saying 2 or 3 basic points. 1. 7, for example, your lordship mentioned, which is dealt with in my later section E. There are others, 7 along with 3 or 4 other sections, which I've cited in my section E, are actually indicative of expansion beyond parties in the traditional sense. Not indicative of limitation, but of expansion. In the old pre-96 era, your lordship would have more easily looked at only signatories or bilateral, trilateral contracting signing parties. Take, for example, I'm giving a much larger answer, I'm just reacting to the 7 your lordship mentioned. Take, for example, B and C of 7. The idea, in fact, is to expand it immeasurably, which could never be thought of by a 1940 Act practitioner. Non-signing parties, non-parties to a contract, who are evidencing, Malas, a relationship to be bound by an exchange of documents or an exchange of pleadings. I'm Malas doing a running paraphrase.
You're right.
Running paraphrase.
Right.
Now,
But the problem is that 7.4b and 7.4c, actually 7.4a, 7.4b and 7.4c
yes.
are all indicative of the fact that though the arbitration clause may not be in the parent contract, so to speak, it yet has to emerge from a course of written dealings between the parties, right? Therefore, in a document signed by the parties, an exchange of letters, an exchange of statements of claim and defense. So all of them, A, B, and C, are instances of a written commitment.
Parties.
Now, what we are trying to explore is whether the extension of the arbitration agreement can take place by a conduct of a party in, say, supporting the contract or implementing a contract, a parent,
Yes.
in relation to a subsidiary, so on and so forth. That can we really contemplate when 2 things. 737 arbitration agreement shall be in writing. Therefore, if you impose this now if you interpose this in 7.1, it means arbitration agreement means a written agreement by the party all or certain disputes which have arisen or which may arise between them. Now, between them means whom? The
Stated.
parties to them means the parties to the agreement. Now, parties to what? Parties to the written agreement. I mean,
Your
if you take
issues
a
who
very
are
little
parties?
construction, if you take a literal construction of this, therefore, them would mean the parties to the agreement. Which agreement? The written agreement. It can be expanded to include, say, a statement of claim and defense. But then again, it's parties to the agreement.
So real issues, who are parties? Who are parties? Who are parties is one of the core questions. Give me just two minutes.
And though none of the judgments has considered it, you may also consider it from another point of view of Section 91 of the Evidence Act.
Yes.
See, because once you have a written contract, then any oral evidence to establish the terms of the contract for adding to the terms of the contract is inadmissible under our law. 91 and 92 come under way.
Correct. Well, first of all, let me take it. Interpretation.
You're right about, on the first part, you need not really elaborate the desirability, the fact that Fluoro has been in the field for 10 years. That absolutely, as a matter of commercial wisdom.
Yes.
As a matter of fact, otherwise what will happen according to you is that you will set up only a shell company and the person behind the shell company will go scot-free. We see all that point. That's all the judge. But then we now have to find some textual grounding.
That's the point.
Just continuing from what Honorable Chief Justice has said, the play that we have from the previous regime, if you compare both the sections, Section 7 and the section under 1940, of course, there is definitely some amount of expansion. So the fluoro control and the subsequent progeny, as you call them, will have to be fitted within Section 7, expanded, and no further.
Of course.
No further, you can't go further. So therefore, to say justice orientation, so therefore we will see case to case and then see, it's impermissible. 1 minute, let me just complete. And in Section 7, there is a scope. Section 7 talks about 3 stages. Stage number 1, pre-agreement. Second is during the process of agreement. And third is thereafter. In these 3 stages, if something can be considered akin to a party who is a signatory, it provides, to that extent, it is permissible. The principle of fluoro control can be seen. If you see each of these sections,
A, C refers to a document. B refers to exchange of letters, etc., etc. C is a clear indication that can be post-contract also, when disputes are
Leadings.
Because when you file a statement of claim and a defense, that is obviously after the dispute has arisen. Therefore, it is post-dispute. So an arbitration agreement can also be implied when it's in writing, arising for the fact that it is asserted by one party and denied by the other in a claim and defense.
Correct.
It is after disputes have arisen between them. So one thing is very clear, that the arbitration agreement does not always have to be a pre-dispute arbitration agreement. It can be a post-dispute arbitration agreement also.
So let me, I'm grateful.
And also just focus on later on, I mean, I just raised it, just for the, otherwise I forget it myself. Section 91 will really affect us because
Yes.
91 or 92 of the Evidence Act.
Therefore, let me
But Dr. Singh, you have to give us a little bit of a statutory handle to for conceptualize and formulate. Now
Next.
it's for a
Straight away, straight away. Now, let me just sum up in the light of these questions.
I mean, very learned authorities have supported the doctrine. I mean, they know what, but you know, I mean,
Why your lordship
now
should not
interpreting Indian laws.
have any doubt about the fact that the statute does not inhibit it. That's what I'm now addressing. Statute will not inhibit or prohibit or stop us in any way.
Does it by the words which are used in section 7, inhibit or stop it?
Answer is no. Tell Shibai. Tell Shibai. The real question is when down to the word parties is used right through the act, everywhere, including 7, 2H, etc. 8. Parties. Question is, was the intention ever to limit parties to signatories? If your lordship's brothers cannot look beyond the signatories, then brothers, look at the 3 underpinnings of the development of this law.
Yes.
The 3 underpinnings of the development of the group doctrine are already available and they provide a sufficient safeguard. And justice is only a trigger for your lordships to go and look at that direction. Is not at all the determining factor. What are the 3 underpinnings? And that is the best answer to your lordship query, in my opinion, which gives your lordships a restraining field. First, and many of them are in fluoro and some are in the later judgments. First, there must be a interconnection, a group which is clearly visible, heavily interconnected in the negotiation and implementation of the contract, performance of the contract. 90% of your lordships' brothers' fears and anxieties about other cases will go out of this test alone. Should be a very closely, this is the first test of fluoro actually, interconnected group, not in the abstract sense, for that contract, for that performance, for that refinery project, for that building. I'm not saying whether that otherwise interconnected with his parent company in USA. For that contract and performance, they have to be interconnected. Number 2 condition, there has to be a mother agreement with an arbitration clause. And your lordships has to find it to be a mother agreement, not my say. How many cases will not be at all?
So there
has to be a mother agreement.
So 2 conditions you say. There's
third.
connection.
I'm now making it.
We just formulated one.
Yes.
First
is the group doctrine is based on a set of highly interconnected entities associated in the negotiation and performance of the contract, of that contract, I would say. Not in their own headquarters.
Associated in?
A set of interconnected entities associated in the negotiation and or performance of the contract.
Associated in making and performance of contract.
Of that particular contract, yes.
Thank you.
Each of the points I'm moving, get the pattern ready.
I forgot this. So you said the group doctrine is based on a set of highly interconnected entities associated with the negotiation and or performance of the contract.
Or as my lord put it, making and performance.
That's the second
Same thing. Same thing. Second, your lordship has to find what is called a mother agreement. It is your lordship's finding that it is a mother agreement. That is two. That also be called 2A. And 2B will be that mother agreement has to have an arbitration clause. This itself whittles down the concept of abuse. I'm not going to suggest that your lordship goes into a justice inquiry straight away. Now, third, this mother agreement with an arbitration clause must give birth to or spawn progeny agreements, one or more. This mother agreement with an arbitration clause must give birth to or spawn one or more progeny agreements. Number 4, the progeny agreements would not have an arbitration clause, otherwise the issue will not arise. Or it may be one of them out of 4 has it, 3 of them don't have it. That also happens. These are progeny agreements, no arbitration clause.
But the progeny agreements will be between whom? The claimant and the third party, or the defendant is the third party?
Now, what is happening in this case?
Can it be completely unconnected to the original parties?
No, these are all with the project. No, I'm not. I'm saying everything with the project. I'm sorry, I didn't add that. Both the mother agreement and obviously, I'm sorry, the first sentence said so, I did not add it. Both the main mother agreement is quite the project only. We are talking only, that's the point. Your lordship has somebody sitting in America doing other projects with the mother agreement, we are not concerned.
Right.
Mother agreement without arbitration clause, quit the project. Fourth, in the context of the dispute arising, this will be post-dispute. These 3 are not enough. 1, 2, and 3 or 4, I can't come to your lordship and say, send me to arbitration with that mother agreement chap. I'm sorry, with the progeny agreement people. This is the other cumulative condition precedent. After the dispute arises, your lordship should have some finding that it is necessary, which includes justice, to read all of them into a common arbitration. That is a supra-added condition. It's not merely the existence of the first 3. There must be a necessity based on a sense of justice or injustice. So it's the reverse, it's the last. It's not the trigger for the actual finding. Now, let me complete this. This is only the next point related to the query. Very good. Into this, your lordship has to weave the extent, if any, to which your lordship is prohibited or inhibited by the Act. My answer is simple, unless your lordship is forced to read parties to meet signatories, which would be a completely wrong interpretation. Your lordship is not inhibited. So long as your lordship does not accept the proposition that parties must be signatories, which cannot be the law, according to me, then your lordship's inhibition in all sections goes away. It is because the subtext of every submission on the other side has to be that parties in some sense, not quite adumbrated, means only signatories, that this problem is arising. Next. Then, the next aspect I'm very pointedly answering this part. I'll be again expanding and go to the case law ones. Next aspect. 91, your lordship need not be worried about. 91 is a straightforward provision which says, a contract says, I must give you black and I must do it in 5 days.
You can't vary the terms.
I cannot get him as a witness and say that it can be a shade of grey and it can be 4.5 days or 5.5 days. That's all. Now, unless your lordship will, which cannot be again, is told to construe 91 to mean that the contract says singvi, but your lordship is applying arbitration to Rana. That also technically is 4.5 days and grey. That's not the way your lordship looks at it. It can't be that I have signed it and Mr. Rana here is not technically, his name is not in the contract. So, 91 your lordship may keep out altogether, your lordship may rest assured there will be no bar, no inhibition, no problem of 91. And it is in this sense that actually I am putting justice against me. I am very grateful for my Lord's query. I am not putting it in my favor, I am putting justice point against me. Suppose my Lord finds all my points cumulatively in a case, but does not find the necessity of the justice to do it. So it's a supra-added point. Your lordship must need to do it to effectuate justice in that context. That's how I meant justice. So actually it's a point against me if at all, or at least it makes the threshold bigger against me. The next issue, these are not a matter of teleological, it's a matter of your lordship's judicial policy interpretation. For something like this, which does not fragment adjudication, fragmentation is a very important thing. Your lordship needs a specific bar in the statute. Well, it's so easy. Suppose the lordship's constitutional bench comes in an extreme manner. I'm not saying, I'm just saying, take an extreme judgment. Everybody will design contracts to make the adjudication and arbitration meaningless. The adjudication, the arbitration is meaningless because I have to file one arbitration, win something, file a second one, third one. Fragmentation is a complete The other phrase which goes with my first point of integrity is composite transaction. Remember, all my principles are for a transaction. I'm not repeating it. It's a very important point made by Justice Narasimha. I'm not suggesting general relationships, that project, that contract, that composite transaction. That's the point.
In modern world, most of these contracts leading to multiple arbitrations and all these are invariably composite contracts.
Which is why,
Building of an airport, DMRC, whatever it is.
Grateful. Why, because in the same group, your lordship has a construction expertise company and a design expertise company. And sometimes they may not know each other. But they are making the same airport. One is liable to arbitration, the other one goes in a suit. It is therefore no coincidence that this doctrine has come to us from abroad. We are not the inventors. They invented it earlier in other countries because they had these kind of contracts my Lord is mentioning now. They have been using this doctrine. The three phrases will really intermesh and intersect. Interconnected, composite transaction, and sometimes it is called single economic entity. It is certainly not single economic entity, but in a technical sense. The mother company and the progeny. It can't be literally called a single economic entity. Why is it called like that? So much of material has the same phrase. Because your lordship is ultimately looking at the core. In a technical sense, no. And these 5-6 conditions will take care of the very, very important aspect underlined by my Lord Mr. Narasimha. Public law. Because public law, your lordship judicial review is massive. India has judicial review for decades, which would make Marbury and Madison blush. For decades, not now. that judicial review in public law domain, your lordship is, if your lordship were to bring an inch of it into this, it would be a revolutionary thing. Not even an inch is coming here. So your lordship's Malas is rightly demarcating this public law, private law spheres, where although sometimes other than other issues of maintainability of writ, the lordship has mellowed it down, but we are not concerned with all that. Your lordship need not, I'm now trying to assuage an anxiety, a potential anxiety, that your lordship will bring in public law remedies or public law concerns. No, your lordship will not.
Much of what you have indicated
Yes.
can possibly be constructed and read into section 7 itself.
Now, exactly. Allow me. There is not a single word which I have said which cannot be read into and is consistent with 7.
Only B.
No one.
That is your section E, I think, right?
Once your lordship, once your lordship accepts parties is okay. Once your lordship accepts parties is not signatories. But let me give you a simple example. Because I am doing a project of a bridge. I have emails from 3 foreign people, all part of the same group. But one is design, one is construction contract. I have a heavy email inflow and I write to all 3 of them. Ultimately, your lordship fructifies in one contract with one of them, which has an arbitration clause. But the exchange between me and those 3, design this, design that, construction this, load factor that, etc., with 3 companies, part of some larger group for that particular project is very heavy. Would it not come under B? Ultimately, the arbitration clause is limited to 1.
This group of companies, the example that you gave is actually a good example. Let us say a very major project, airport.
Yes.
You have the design person coming in, providing the design, somebody is constructing, and somebody is executing maybe also additionally. Now the design person may be part of the same group. It is one contract, you are talking about the airport. The design person has given the design on basis of whatever value he charges for providing the design. But then beyond that, he's not involved with the contract. Although his design is being utilized for the contract. Now, so far as the design company, Progeny contract, does he come in?
Straight away. With your lordship example, remember, we are talking of dispute resolution, not merits. We are talking of suit versus arbitration. That's the only issue today. In this example, just add 2 sentences, the bridge collapses and the report finds it's a design fault.
That is culpability. That is culpability.
No, I'm saying dispute arise.
Dispute arise, all right.
I file an arbitration against the signatory. How do I get this design fault worked out of the arbitration? Should I file a suit against him?
But he is providing the design to the executor of the contract, the person who has signed the contract, and he has brought forth that design.
No, if he is not a separate entity, then the issue will not arise. Then it's enough to sue that man. If this person is subsumed, well, suppose I am the owner and he's the builder of that airport, within his there's a department which does design.
No.
Then it is, if
Department
it's a separate entity, then it's a right.
No, that's right. That within that, executor of the contract department, they would definitely be part of the.
They'll be covered by, if I sue him, I sue them.
That's right.
Yes. However, if well, it's the sister concern, let's use
Sister concern,
loose word.
loosely, yes.
Loose word. We don't know yet why it's never called a brother concern. It's always called a sister concern. But anyway, his sister. Well, this is a reverse gender neutrality. There could be an objection on this for us. But sister concern directly involved. The fault is both of that person who does it and the person who does the design. Then well, this is fragmentation. Exactly the query by Lord is putting is the fragmentation issue. Incomplete justice, fragmentation, injustice. Exactly.
Should there be separate proceedings for such an issue?
Because you're only considering dispute resolution, not the merits. Who will win is not the issue. Whether the culpability is right or wrong. What is arbitration? Well, they have chosen to arbitrate to keep away from court. In this case, it will be international arbitration even more.
Dr. Singh, would you like to now go to E, your section, E in your written submission, because that
Without going to E, you should just keep the act in your hand. It is E only. Just keep the act. Because that's really the query which, in a sense, was anticipated.
That's the crux of the matter.
So we'll just see. Well, according to me, what I've said, I can't improve on what I've said, the 7 principles. But well, 2(1)H, if your lordship does not limit to signatories, the whole problem is solved. Of course, I don't limit to signatories.
7 is clear, it can't be.
Only 7, 2(1)H. Unless your 7, I have made my submission, my lord has noted it. Unless your lordship is compelled to interpret and limit 2(1)H to signatories. I substitute the word signatory for party, which fellows can have very alarming results.
It can't be because
Yes.
party is defined in terms of.
I am very grateful.
Agreement which is in 7.
I am very grateful. Even otherwise, fellows, look at your lordship is trying to limit some doctrine. rightly, in that process, your lordship will have to look at the other consequences for us. If it's only signatories, this design example was giving me a design in delay, performance problems. To have a quick run through the act, there are 5 sections I've identified. I may not be correct, but there may be more lordship may have in mind. The 5 I've identified. Just see 2.1G before that. Now, this is not about the subject matter today at hand.
Legal
I'm
representation.
only by analogy. And I've dealt with 2.1G at page, at E1 and E2. Don't go to it, just note the paras, E1 and E2. 2.1G is another form of expansion. Of course, the object is salutary that if the main person dies, the LRs, the arbitration doesn't end. So 2G, but it's a form of expansion. 2.1G goes with 40 minutes. This word in 2.1G is in 40. So whether the main so-called party dies, it's not relevant for today, I'm giving an analogy. Now, 2.1H, I have said, is a much wider meaning. My Lord Justice Narasimha has just underlined a particular facet which I've already mentioned earlier, but you should keep that facet in mind. Then comes 7, which we have discussed in some detail. This is all covered in E1. This is all part of E. And then 8, the amendment. Now, I have run out of sections after this. 2.1G, H, 7, 8, and 40. Now, you cannot now be asked to create a section which is some kind of an imagined interdiction of your lordship's power. Which is that other section? Or for that matter, which is that particular object of the Arbitration Act, or even I will go behind to the Travo Preparatoire of the UNCITRA, which suggests that your lordship should limit it to signatories alone. Nothing is shown to your lordships. To the best of my knowledge, nothing exists. And the 5 sections which I have found are these ones, which can be construed this way or that way, some expansion, some inhibition. My Lord has already discussed the basic one, actually only 2, H and 3, H, 7 and 8. H, 7 and 8. 1, H, 7 and 8. So, if your lordship has a doctrine in Indian jurisprudence and earlier recognized in foreign jurisprudence, today the question is how much more your lordship will curb it without an actual limitation in the act. Should your lordships curb it and how much? Of course, technically I should have mentioned 45 also. It doesn't arise. So in technical.
Concept of an affiliate,
Again,
the concept of an affiliate is also brought in the 5th schedule, a completely different context.
Yes, yes.
Where that issue of justifiable doubts as to the integrity or
Correct.
Independent.
Yeah.
Correct.
See item 5,
Correct.
entry 5
So Rashmi will add 45 and the fifth schedule.
is an affiliate of one of the parties if the affiliate is directly involved in the matters in dispute in the arbitration.
That's well, I should have said it.
Context.
No, I should have said it. It's a point in my favor if your lordship at all is looking for expansion. Not that, because when your lordship has bias and conflict, this should be an affiliate approach. But I'm just saying, there is that expansion also. 45 I have not mentioned, fifth schedule I have not mentioned. Your lordship may want to, for completeness, add. 45 is obvious.
Many of those judgments have relied on 8, but 8
Eight is not,
is a little problematic to rely on 8. Because 8 is the power of the judicial authority, number one. And secondly, that party or somebody, any person claiming through him may apply. But that expression will not lend to who the parties are and expand. I mean, you can't
I
do
bow
that
down.
reverse,
It
that
is-
reverse engineering can't be
It
done.
is,
But expansion can be done, of course, on the basis of section 787.
well, I bow down. It is my case that 8 is the least of my juristic basis.
But most of the judgments have relied on it.
2-1H and then
Whereas non-signatories, no, on common law.
7.
Whereas common law is as well a part of your lordship's binding law unless the statute nullifies it. Common law, which has these conditions precedent, which have already limited it, they are the better basis. Mother agreement, same project, progeny agreement, one has arbitration, others don't have arbitration. What is wrong with these principles? Statute doesn't say it. Do they become, does a non-statutory common law become bad for any reason? 8 is the least of my basis. Even in my note, I put it for completeness.
Yes.
But it's the last. 8 is an additional point.
Because of 45, chloro control dealt with 45. Then
Yes.
came the law commission. Law commission said amend it.
No, because much was made of
8 and 45
Yes,
came
yes.
into the argument.
Also, much was made of 2-1H. And
Right.
why was it not correspondingly amended and all that? That's why we put it there. I would say, the common law reasoning, which is a automatic inbuilt public interest limitation, is sufficient. It is for them to point out an inhibition. It is not for me to point out an affirmation. This is whole case, if I may say so, the approach is a little bit skewed as far as the rival arguments are concerned. It is for me not to point out an affirmative basis. It is there in the common law. It is for them to point out an inhibition
Right.
or a prohibition. Now come to chloro straight away. See that common law creation. Now, just 2 or 3 portions of judgments are important. Come to Miller's CL1 at page 63. 62, I'm sorry.
Your,
Para
for your
71.
compilation,
Compilation 1, CL1, case law 1, I called it. And not CJ1, it was called the last case.
Compilation 1.
and
Para 71 at page 62 is chloro. Actually, yeah.
We're reading para 71.
Of chloro at page 63.
Yes.
Sorry, 62. My apologies. 62.
Page 62, para
71.
correct.
We have a factual para where the mother unit is described properly. Though there is a chart there. This page, just mark this page.
Okay, of course.
Though the scope, this is
Yes.
well, it's just flag 62, but I forgot to say one factual aspect at para 11 at page 43. I'm sorry to jump us. Just that one chart is necessary to give it also a flavor, and then come to 62. This is at CL1 page 43 in the same judgment. This gives you a graphic idea of how the case arose for us. Dispute balance with these various companies, including number 2, 3, and 6 in that chart. In fact, whereas the hottest one was with 6 and 2, both of which didn't have an arbitration clause. And your lordship gets the mother agreement in item 1. This is actually the best way to illustrate the practical dilemma of a judge who is told that only signatories will be looked at, the others are not to be looked at. This is one of the very graphic examples. It is in this sense that I mean justice as a supra-added condition at the end. I don't mean a lordship embarks of justice straight away in a broad sense. Now come to 62. Para 71, page 62. My lord has got yes, no in the last column at page 53. 3 yeses and 3 noes. Though the scope of an arbitration agreement is limited to the parties who entered into it and those claiming under or through them, the courts under English law have in certain cases also applied the group of companies doctrine. This doctrine has developed in the international context whereby an arbitration agreement entered into by a company, being one within a group of companies, can bind its non-signatory affiliates. The real operative phrase is non-signatory according to me. Once that is sufficiently covered, then the act is not a bar. Non-signatory. Non-signatory affiliates or sister or parent. if the circumstances demonstrate that the mutual intention of all the parties was to bind both the signatories and the non-signatory affiliates. This will mark the word mutual intention. This theory has been applied in a number of affiliation arbitrations so as to justify a tribunal taking jurisdiction, over a party who is not a signatory to the contract containing the arbitration agreement. Russell, a very much more conservative jurisdiction was England, very much more conservative. This involves the principle that a non-signatory party could be subjected to arbitration provided these transactions were with group of companies and there was a clear intention of the parties to bind both the signatory as well as the non-signatory parties. In other words, intention of the parties is a very significant feature which must be established before the scope of arbitration can be said to include the signatory as well as the non-signatory. Why is this not a sufficient? Your Lordship is finding intention in every case for us, searching for it. This is a very good limitation. It is not a jungle rather where somebody has come and says group, and a Lordship embarks on group piercing. Lordship examines the intention. That's the right way. This is a very strong safeguard. A non-signatory or a third party could be subjected to arbitration without their prior consent, but this would be only in exceptional cases. The court will examine these exceptions from the touchstone of direct relationship to the party signatory to the arbitration agreement, direct commonality of the subject matter, and the agreement between the parties being a composite transaction. All this is required, composite transaction, interconnected. The transaction should be of a composite nature where performance of the mother agreement may not be feasible without aid, execution and performance of the supplementary or ancillary agreements. For achieving the common object and collectively having a bearing on the dispute. Besides all this, the court would have to examine whether a composite reference of such parties would serve the ends of justice. In this sense, I am saying as an aid, reinforcing, certainly not as a standalone. Once this exercise is completed, the court answers the same in the affirmative. The reference to even non-signatory parties would fall within the exception of that clause here. Suppose my Lord reads this sentence to 2, 1, and 7. Because all problems very hardly applies and safeguards apply. It is harmonious. You will not have no inhibition. Then let us come to 76. Very good one.
The concept of the mother agreement comes in 74.
I'm grateful. Mother agreement is mentioned in 73. Now, at class item C, let me read 74. I'm grateful. In a case like the present one, where origin and end of all is with the mother of the principal agreement, I'm grateful. The fact that a party was non-signatory to one or the other agreement may not be of much significance. The performance of any one of the agreements may be quite irrelevant without the performance and fulfillment of the principle of the mother agreement. Besides designing the corporate management to successfully complete the joint ventures, where the parties execute different agreements, but all with one primary object in mind, that's the airport. The court would normally hold the parties to the bargain of arbitration and not encourage its avoidance. In cases involving execution of such multiple agreements, two essential features exist. Firstly, all ancillary agreements are relatable to the mother agreement, not a standalone. Progeny has to have an umbilical cord, very strong umbilical cord. And secondly, performance if one is so intrinsically interlinked with the other agreements that they are incapable of being beneficially performed without performance of the others or severed from the rest. In exceptional cases, I am conceding, there ought to be even severed in exceptional cases, where it is totally unrelated. It's a temporary contract without arbitration clause for those providing a car in the first 3 months. Nobody is saying that will also go to arbitration. The intention of the parties to refer all the disputes is one of the determinative factors. So 74, I'm very grateful, very important. We may notice that this doctrine does not have universal acceptance, but they have discussed other jurisdictions. Can I come to 76 first?
Yes. Yes.
The court will have to examine such pleas with greater caution and by definite reference to the language of the contract and intention of the parties. In the case of composite transaction and multiple agreements, it may again be possible to invoke such principle in accepting the pleas of non-signatory parties for reference to arbitration. Again, the word is non-signatory. Where the agreements are consequential, another very important test. And in the nature of a follow-up to the principal or mother agreement, the latter containing the arbitration agreement and such agreements being so intrinsically intermingled, mark the word, intrinsically intermingled or interdependent, that it is their composite performance which shall discharge the parties of the respective mutual obligations. This would be a sufficient indicator of intent of the parties to refer signatory as well as non-signatory parties. The principle of composite performance would have to be gathered from the conjoint reading of the principal and supplementary agreements on the one hand, and the explicit intention of the parties in the attendance. First, just 30 seconds diversion. Justice Roy asks, suppose there is heavily interlinked in composite, but there's a clause which says, no, you shall not touch the other companies. The conduct and the nature will prevail, not that exemption clause. Then, Maras, that's all. Now, Maras, I don't think I can need to read it. Come to 103 for a second. 103 is page. Page 74. Now they are giving us juristic theories to justify the doctrine. In fact, may I read from 102? It's very interesting. The learned authors from 101 onwards all recognize that there could be a doctrine like this. Muster and Boyd is 101. I'll not read it. Muster and Boyd is there. Then 102 is joinder of non-signatory parties to arbitration not unknown to arbitration jurisprudence. Even the ICA's guide to interpretation of the 58 Convention provides for such situations, stating that when the question arises as to whether binding a non-signatory to an arbitration agreement could be read as being in conflict with the requirement of written agreement, the most compelling answer is no. Various legal bases may be applied to bind a non-signatory to an arbitration agreement. Now they come, the Supreme Court of India says this is the legal basis. The first theory is that of implied consent, third-party beneficiaries, guarantors, assignment, and other transfer mechanism of contractual rights. This theory relies on the discernible intention of the parties and to a large extent on the good faith principle. They apply to private as also public legal entities. Second theory includes the legal doctrines of agent-principal relations, apparent authority, piercing of veil, called alter ego, joint venture relations, succession and estoppel. They do not rely on the party's intention, but rather on the force of the applicable law. Then, the Canadian case is noted. Then, 105, we have already discussed that under the group of companies doctrine, an arbitration agreement entered into by a company within a group of companies can bind its non-signatory affiliates if these circumstances demonstrate mutual intention. That's the basic test. Then, come to 107. If one analyzes the above cases in the author's views, becomes abundantly clear that reference to even non-signatory parties to an arbitration agreement can be made. It may be the result of implied or specific consent or judicial determination. Normally, the parties to the arbitration agreement calling for arbitral reference should be the same as those to the action. This general concept is subject to exceptions, which are that when a third party non-signatory is claiming or is sued as being directly affected through a party to the arbitration agreement, and there are principal and subsidiary agreements, and such third party is signatory to a subsidiary agreement and not to the mother or principal agreement which contains the arbitration clause, then depending upon the facts of the given case, it not be possible to say that even such third party, it may be possible, my apologies, to say that even such third party is referred to arbitration. What is wrong with this, fellows? What is so anathema in Indian statute to this? Then let us come to Charan, which is
Dr. Singhi, is there any judgment which you would have seen is a little off the mark? Goes a little overboard. More or less, every of these subsequent judgment perhaps is in line with Chloro. But is there any judgment? Because there's no point in reading judgments which is more or less in the same principle. But if there's something off the mark which you can...
It needs correction or comment or the streamline.
Is there anything?
There is some paragraph which is completely of the mark, which they can correct with the constitution. I just revert. Now let us come to Charan, which I had the pleasure of arguing at 162, same volume. Facts are different, but the principle are. Facts are very different. As I said, the proxy setup afterwards. Page 158.
Yes. 158.
158. Para is 23.
This is the example which he gave.
Strategy of picking up the Chief Justice's judgments only, right?
The problem arises sometimes because he's writing a lot of judgments. That's the problem. So there are plenty here which are not by him also.
No,
Coming up.
occupied field we are just discussing.
Yes. But what is the best answer to this was given by Justice Chirappa Reddy, who told me that I will be waiting for an opportunity to overrule myself. In a constitution bench, a lordship has that option.
Yes. Justice Bhagwati did that in the section 80M, if you remember. 80M of the Income Tax Act.
Yeah.
It came on review and he said he overruled his view.
Loya machines.
Loya machine was what I say. Maybe
Yeah.
Loya.
Loya machine. There.
23 Manas. As the law has evolved, it has recognized that modern business transactions are often effectuated through multiple layers and agreements. There may be transactions within a group of companies. The circumstances in which they have entered into may reflect an intention to bind both signatory and non-signatory entities within the same. That's the simple principle, Manas of Toro. Reflect the intention to bind both signatory and non-signatory parties. In holding a non-signatory bound by an arbitration agreement, the court approaches the matter by attributing to the transactions a meaning consistent with the business sense which was intended to be ascribed to them. Therefore, factors such as the relationship of a non-signatory to a party, which is a signatory to the agreement, that is one test, the commonality of subject matter, and the composite nature of the transaction weigh in the balance. What is wrong with Yoshua? Enough safeguards. The group of companies doctrine is essentially intended to facilitate the fulfillment of a mutually held intent between the parties, where the circumstances indicate that the intent was to bind both signatories and non-signatories. The effort is to find the true essence of the business arrangement and to unravel from a layered structure of commercial arrangements. Very important word. An intent to bind someone who is not formally a signatory, but has assumed the obligations to be bound by the actions of a signatory. Then my Lord touches on uncitral. Now, I am saying this is already answered. Unless you find something grievously wrong with this, there is no reason to reconsider this. Non-signatory uncitral is discussing. Section 7 is discussing. May I read 24 also, although I want to read 25, read 24. International conventions as well as uncitral model mandate that an arbitration agreement must be in writing. 7 affirms the same principle. Why? Does the law postulate there should be written agreement to arbitrate? Reason is simple. Agreement to arbitrate excludes the jurisdiction of national courts. Where parties have agreed to resolve their disputes by arbitration, they seek to substitute a private forum for dispute resolution in place of adjudicatory institutions. According to Redfern, The requirement of an agreement to arbitrate in writing is an elucidation of the principle that the existence of such an agreement should be clearly established, since its effect is to exclude the authority of national courts to adjudicate upon disputes. Does the requirement as in section 7 that an arbitration agreement be in writing exclude the possibility of binding third parties? This is was directly answered by Lordship, the query Lordship asked me in the morning. Now it can be wrong, you're a constitution bench, but what wrong is pointed out was here. Directly the same question. Does the requirement as it, I'm sorry,
We'll come back after. Yes. How long will it take now?
About half an hour, 40 minutes. But I'll start with a small Article 14 complaint against Mr. Mehta, who was missing in the morning. Article 14 complaint is well as that he has existing in the enormous power also hogged all the charging points on that side. The Lordship has got no charging points this side at all.
You are fully
Neither
charged
present
all the
table,
time.
nor here. They are already so charged there. Already they are so charged.
Charging points are in the.
लॉर्डशिप वहाँ
No,
वायर
they
नहीं
are
आ
not
रही
middle.
वो दूसरा लगवा देंगे वहाँ पे।
My court master has an answer for everything. He'll make sure.
No, we told him yesterday.
He said शाम तक evening तक और एक वायर लगवा देंगे. So
No, I'm not. He said he.
He doesn't have an answer. He has a solution for every problem.
Considering that he's already so charged, Manoj, he doesn't need a charging point. We needed more this side.
Para 25 we were.
Now let's para 23, my lord is seen. Now come to para 25. Does the requirement as in section, that is what is at page 158. Does the requirement as in section 7 that an arbitration agreement may be in writing exclude the possibility of binding third parties? So well, every point is considered and I think very logically dealt with. There's no need to reconsider any of these, including safeguard limitations, contours and content. That's the point. Who may not be signatories to an agreement between two contracting entities. The evolving body of academic literature as well as adjudicatory trends indicate that in certain situations, an arbitration agreement between two or more parties may operate to bind other parties as well. Redfern and Hunter say this, but it is important. The requirement of a signed agreement in writing, however, does not altogether exclude the possibility of an arbitration agreement concluded in proper form between two or more parties, also binding other parties. Third parties to an arbitration agreement have been held to be bound by or entitled to rely upon such an agreement in a variety of ways. First, by operation of the group of companies doctrine pursuant to which the benefits and duties arising from an arbitration agreement may in certain circumstances be extended to other members of the same group of companies. Secondly, by operation of general rules of private law, principally on assignment, agency and succession, the group of companies doctrine has been applied to pierce the corporate veil to locate the true party in interest. I use the word true intent in the morning. And more significantly, to target the creditworthy member of a group of companies. Though the extension of this doctrine is met with resistance on the basis of the legal imputation of corporate personality, the application of the doctrine turns on a construction of the arbitration agreement and the circumstances relating to the entry into the performance of the underlying contract. Well, just note, at the end of it is nothing but the Salomon principle, which is supposedly inhibiting your lordships. Salomon principle has had so many exceptions over the last hundreds of years that it doesn't anymore act as an inhibitor. The one is Gary Bond, Gary is misspelled, in the International Commercial Arbitration says this: the principal legal basis for holding that a non-signatory is bound and benefited by an arbitration agreement include both purely
Yeah.
I was on 27, skipped 26. And after the first part of Gary Bond in 27, come to page 160. Explaining the application of the alter ego principle in arbitration, Bond notes, authorities from virtually all jurisdictions hold that a party who has to be bound by the clause, if that party is an alter ego of an entity that did execute or was otherwise a party to the agreement, this is a significant but exceptional departure from the fundamental principle that each company in a group of companies, a relatively modern concept, is a separate legal entity possessed of separate rights and liabilities. Explaining the group doctrine, Bond says, the doctrine provides that a non-signatory may be bound by an arbitration agreement, may is important, where a group of companies exists and the parties have engaged in conduct, such as negotiation or performance of the relevant contract, or made statements indicating the intention assessed objectively and in good faith that the non-signatory be bound and benefited by the relevant contracts. While the alter ego principle is a rule of law which disregards the effects of incorporation or separate legal personality, in contrast, the group of companies doctrine is a means of identifying the intentions of parties and does not disturb the legal personality of the entities in question. In other words, the group of companies doctrine is akin to principles of agency or implied consent. I dealt with implied consent earlier, whereby the corporate affiliations among distant legal entities provide the foundation for concluding that they were intended to be parties to an agreement, notwithstanding their formal status as non-signatories. Well, I am also saying that everything possible has been dealt with by our lordships, and none of it seems to be absurd or illogical or something requiring consideration or rewriting. I now leave this and come to MTNL. Please turn to 2 paras of MTNL. Start with page 204. That's called the Losses Canada MTNL versus 195, Act 204.
I relied on section 35 of the Arbitration Act. The award binds those who are claiming under a party. And the finding was that the appellant was claiming under a party to the agreement, eventually in this case.
In that case, yes.
In that case,
yes, correct. But my lords also relied on a larger principle.
Yes.
Much larger principle. My question to myself is, there has to be something objectionable shown in the larger principle of lordship. That's the real point.
Which is the next judgment?
Next is MTNL Canada, which is the relevant portion at 9.4, the relevant page is 204 of the same compilation, CL1. It starts at 195, but that's not relevant. Arbitration agreements are to be construed according to the general principles of construction of statutory instruments and other contractual documents. The intention of the parties must be inferred from the terms of the contract, conduct of the parties, correspondence exchanged to ascertain the existence of a binding contract between the parties. If the documents on record show that the parties were allied and had actually reached an agreement upon all material terms, then it would be construed to be a binding contract. The meaning of a contract must be gathered by adopting a common sense approach and must not be allowed to be thwarted by a pedantic and legalistic interpretation. Brings in a certain amount of justice element. 9.5. A commercial document has to be interpreted in such a manner so as to give effect to the agreement rather than to invalidate it. An arbitration agreement is a commercial document inter partes, must be interpreted so as to give effect to the intention of the parties rather than to invalidate it on technicalities. In my understanding, Your Lordship is using it in the more expansive sense, invalidation and technicalities, as opposed to a restrictive sense. Then 9.7, same page. In interpreting or construing an arbitration agreement or arbitration clause, with duty of the court to make the same workable within the permissible limits of law. Then Your Lordship reads and on. Last sentence of that is, being a commercial contract, the arbitration clause cannot be construed with a purely legalistic mindset as in the case of statute. Then 10.2 is at page 206. Here was the actual issue of joinder of the Scanfina, which is another Canara Bank affiliate, so to say. 10.2. As 206. As per the principles of contract law, an agreement entered into by one of the companies in a group cannot be binding on the other members of the same group, as each company is a separate legal entity which has separate legal rights and liabilities. The parent of the subsidiary company entering into an agreement, unless acting in accord with the principles of agency or representation, will be the only entity in a group to be bound by that agreement. Similarly, an arbitration agreement is also governed by the same principles, and normally, mark the word normally, the company entering into the agreement would alone be bound by it. A non-signatory can be bound by an arbitration agreement on the basis of a group of companies doctrine, where the conduct of the parties evidences a clear intention of the parties to bind both the signatory as well as the non-signatory parties. Courts and tribunals have invoked this doctrine to join a non-signatory member of the group if they are satisfied that the non-signatory company was by reference to the common intention of the parties a necessary party to the contract. The doctrine of group of companies, I'm reading 10.4, has its origins in the 1970s from French arbitration practice. The group of companies doctrine indicates the implied consent to an agreement to arbitrate in the context of modern, mark this word, modern multi-party business transactions. Saint-Gobain was the main case, where the arbitral tribunal held the arbitration clause expressly accepted by certain of the companies of the group should bind the other companies, which by virtue of their role in the conclusion, performance, or termination of the contracts containing the said clauses, and in accordance with the mutual intention of all parties to their proceedings, appear to have been veritable parties to these contracts, or to have been principally concerned by them and the disputes to which they may give rise. The group of companies doctrine has been invoked by courts and tribunals in arbitrations, where an arbitration agreement is entered into by one of the companies in the group and the non-signatory affiliate, kindly see this, the non-signatory affiliate or sister or parent concern is held to be bound by the arbitration agreement if the facts and circumstances of the case demonstrate the mutual intention of all parties to bind both the signatories and the non-signatory affiliates of the group. The doctrine provides that a non-signatory may be bound by an arbitration agreement where the parent or holding company or a member of the group of companies is a signatory to the arbitration agreement and the non-signatory entity of the group has been engaged in the negotiation or performance of the commercial contract or made statements indicating its intention to be bound by the contract. The non-signatory will also be bound and benefited by the relevant contracts. So enough safeguards are inbuilt. It's not an open-ended doctrine. The circumstances in which the group of companies doctrine could be invoked to bind the non-signatory affiliate of a parent company or inclusion of a third party to an arbitration, if there is a direct relationship between the party which is a signatory to the arbitration agreement, direct commonality of the subject matter, the composite nature of the transaction between the parties. A composite transaction refers to a transaction which is interlinked in nature or where the performance of the agreement may not be feasible without the aid, execution and performance of the supplementary or the ancillary agreement for achieving the common object and collectively having a bearing on the dispute. The group doctrine has also been invoked in cases where there is a tight group structure with strong organizational and financial links, so as to constitute a single economic unit or a single economic reality. This is even wider. This is going even beyond. In such a situation, signatory and non-signatories have been bound together under the arbitration agreement. This will apply in particular when the funds of one company are used to financially support or restructure other members of the group. Then I move on to ONGC discovery.
Page 253.
Which you'll also find at page 253. So para. Your para which is the thing.
What?
No, this is my note. No. My note. The dot doesn't connect me. Which page is it?
Is it 286?
No, it's not. Give me a minute, Melissa.
The analysis starts at 276.
Please come to Melissa 276.
Where the analysis starts.
Para of your note.
Point 8.
Give that visually. In this, fellas, please turn to sorry, just 1 minute. Can you see which page?
279.
279. I'm sorry, this is not bookmarked correctly. Para 25 is at 279. May I read, fellas?
Yes.
Subsequently, in fluoro, 3-judge bench, I'll skip the first few lines, brothers, where through or under him, till there I'll skip. I'll come from brothers, below B and above C. Interpreting the expressions through or under in 45, this court held that though an arbitration normally would take place between the parties to the arbitration agreement, it could take place between a signatory to an arbitration and a third party as well. This court held that though the scope of the arbitration agreement is limited to parties who have entered into it and those who claim under or through them, courts under the English law have developed the group of companies doctrine. So there was a limitation which has been expanded by the courts. In substance, the doctrine postulates that an arbitration agreement which has been entered into by a company within a group of companies can bind its non-signatory affiliates or sister concerns if the circumstances demonstrate a mutual intention of the parties to bind both the signatory and the affiliated non-signatory parties. Elaborating, now I'll skip this because 71, 72 my lord has just seen. 71, 72 is quoted, your lordship has got that?
Yes.
That your lordship has seen with me. It's the same quotation. Then para 30 quotes Charan. Again, your lordship has seen that. See the opening part of 30. This quote in Charan also analyzed academic literature. It noted that the written intention to arbitrate between parties can extend to bind non-signatories with the aim to target the credit-worthy member of a group of companies. Mark this first. The sentence is important. My Lord Justice Chandrachud then was says, it noted that the written intention to arbitrate between parties can extend to bind non-signatories with the aim to target the credit-worthy member of the group of companies. However, the principle of separate legal personality also has to be balanced. The corporate veil can be pierced to bind non-signatories upon a construction of the arbitration agreement, the intention at time of entering and the performance of the underlying contract. My Lord cites para 25, which I've just read. So may I just skip it with the Lordship's permission? From the main judgment, I have read 25. Then para 34, the entire law is summarized. Para 34, my Lords, quotes from MTNL, which I have read. Does my Lord have it with us?
You know, this is a very interesting case which shows you how that doctrine can be applied. What happened was that in that case, ONGC had moved an application for discovery and inspection.
Yes.
Now, the tribunal said we will consider the application for discovery and inspection later. They didn't consider it at all. And then they dismissed the, by the interim award, they rejected the claim of ONGC for joining the parent company of the Jindal Drilling Group as a party to the proceedings on the ground that Section 7 only a party to the arbitration, that it's signatory to the arbitration can be included. If you look at the facts,
that's it. Kindly turn to that.
Very interesting how this document
I marked that.
actually unfold. You know that
Let us come to those facts.
from para 42 onwards, or
may I
42 maybe, I think.
Yes. Come to 6 is important. Come to 2 first. At page 263.
260?
263.
263, okay.
Yes.
On facts?
That's para 2 on facts.
No, actually, you can go direct
6
judgment. Para 42, we have put everything together because then you see 3 paras and you'll get a good.
Very well. But your Lordship will just note when I go there. Yeah. Para 6 is the application my Lord is talking about. Just see that 6. Yeah. Don't read it. All the facts my Lord has stated is sequentially put there. An application is moved, deletion, etc., inspection, discovery, all that is written there. But your Lordship will just
leading to the final application.
May I not read it, but just skip it and just ask your Lordship to flag it. 6 is the para my Lord referred to. Now my Lord is on 42. Before that, just tick 36 and 38. So I don't need to go back to it. Just give me 30 seconds. 36 is commentators. Just 10 seconds before I come to that. Noted that a signed written agreement to submit a present or future dispute does not exclude the possibility of an arbitration agreement binding a third party. A non-signatory may be bound by the operation, etc. Then 38, my Lord, very important passage of bond is quoted, which is the alter ego doctrine. Take, for example, if your Lordship unreasonably and theoretically is asked to circumscribe this doctrine, how does my Lord deal with an alter ego case? How will my Lord deal with it? If you are told that you must put boundaries and curb and confine, Alter ego is so well known, Lordship been using it on piercing the veil for the last 100 years or 50 years. What will happen to alter ego? Now come to 42, the para my Lord mentioned. 1 second on 40 minutes, where the 4 tests are given, then 42. So 36, 38, then 40. 4 tests are given there. The mutual intent of the parties in 40. The relationship of a non-signatory to a party which is a signatory, the commonality of the subject matter, the composite nature and the performance. I'm asking myself, are they not good safeguards for your Lordship not to look further, is my question to myself. How are we on a kind of an open ship sailing without any guidelines? These are very useful and very limiting safeguards.
Now just see how we deal with the
Up to
facts.
42. The interim relates to para 6 ultimately.
Yes.
The interim award of the arbitral tribunal is substantially premised on the fact that JDIL is not a party to the contract of 22nd of March. The tribunal held that the agreement was only between ONGC and DEPL. Adverting to section 7, the tribunal held that there must be a written agreement between the parties to submit to arbitration or in the specific manner envisaged under the provision. Before the arbitral tribunal was urged by ONGC that 1. There is a commonality of interest in the business between DEPL and JDIL. 2. DEPL is a corporate facade created by JDIL for their extended business. 3. The executives of JDIL were actively associated in the bidding process. 4. They are situated in the same building. In a sense, Wallace, the tests of piercing the veil will always overlap. You can't ignore it. The arbitral tribunal rejected the above submissions by holding that there was not a tickle, it should be trickle, I would have thought.
Or tittle of evidence. It's an old British phrase which Bombay High Court judges keep.
Oh, I see,
keep on
tickle.
using. Tittle. T-I-T-L.
Not even enough to tickle anybody else. On evidence to show that JDIL, which is a distinct corporate legal entity, ever played any role to find itself in the contract between JDIL and ONGC. The participation of JDIL in the execution of the contract was held to be on behalf of DEPL. And that the fact that the directors of DEPL are son and daughter-in-law of the MD was held not to be of relevance. The fundamental basis of the interim award is that in view of the provision of section 7, so we come back to what we've just seen, and the definition of the expression party in 21H, the provisions of 96 could not be invoked or applied to a non-signatory to an arbitration agreement. Tribunal held no jurisdiction to investigate, inquire into, or record any findings. The tribunal had, by its order of July 2009, specifically held that the objections of JDIL to the production of documents sought by ONGC would be decided when the application under 16 was resolved. Yet, in the interim award, ultimately the tribunal has directed that ONGC's application of 5th of January would stand deferred until the issue of jurisdiction is decided. ONGC was justified in submitting that his application for discovery and inspection should be heard first and disposed of on merits, after which appropriate orders as regards the joinder of parties could be issued. By failing to consider the application for discovery and inspection, the tribunal has foreclosed itself from inquiring into whether there was sufficient material to establish the application of the group of companies doctrine. The application for discovery and inspection is indeed relevant to the exercise which has been carried out. ONGC's primary submissions for impleading were: 1. DEPL has been created by the Jindal Group with a definite purpose to render services in oil and gas. There is a close corporate and functional unity between DEPL and JDIL. The executives of JDIL have been closely associated with the negotiation of the agreement. The bid as well as the contract with DEPL was signed by GD. Sharma was an employee. Sharma was signing letters on behalf of DEPL as well as the authorized signatory. Ramanathan, who was the general manager, used to visit the witness who deposed on behalf in connection with the subject contract. Naresh Kumar, the MD, had negotiated with the owners of the vessel in connection. This is not a finding yet, but to arrive at a finding this way or that way, how can you not even have an inspection or a discovery on these points? These are all the same tests: negotiation, performance, involvement, composite transaction, whatever your Lordship calls it. It's the same test.
Yes.
Then your Lordship has the evidence in 47. Then 48 is your Lordship's finding on the context of that case. the failure to allow the discovery goes to the root of the process. Then I think that is sufficient. Now, in ONGC, that is sufficient. Can I now start winding up the case law by referring to two paras of Cox and Kings? Wind up this case, last three paras, 49.4 and 49.5 also. Your Lordship.
Which one?
Same case Your Lordship is holding at page 288. My Lord is hedging it with lots of safeguards, including exception in 49.5. It's not the straight entry rule. But beyond this, a hedging would be counterproductive is my submission. Beyond the safeguards the Lordship already has.
Yes.
Then, last one, Mr. Hiro Advani read the whole thing, but I want to read two paras again of Cox and Kings.
212, it starts at 212.
Now, Cox and Kings
Starts at 212.
starts at 212
At 251.
and I'm asking your Lordships to go to 249.
Yes.
Now, I will not read this because this part has been read. Just note 91 and 92 at 249 and 250. But just note it again, Malas. This whole thing that no, you are doing violence to the independent corporate personality of companies is how 91 starts. At 249, 250. So 91 and 92. I'm just flagging it and moving on. Now come to 97, which needs emphasis, Malas, at 251. That's why I said, the learned judge need not have referred it after such a lot of laudatory and endorsing comments in favor of the group doctrine. All these are comments which are basis of supporting the doctrine with safeguards. Now see 97. May I read 97 at 251? There are additional benefits of having the group of companies doctrine in Indian jurisprudence. There are benefits earlier. Now, my lord is talking of additional benefits. There are, this is Roy's got it in 97.
Yes, yes.
There are additional benefits of having the group of companies doctrine in Indian jurisprudence. These arise from the peculiar circumstance and manner in which Indian business entities transact with each other and establish commercial relations. Large chunk of Indian business houses composed of family-run entities or groups. Individuals running these entities often occupy multiple roles in different companies within the group. Commonality in terms of key managerial personnel and the preponderance of family members occupying these positions molds the way these companies conduct business. Entering into commercial transactions involves informal understandings based on familiarity with persons who run the overall companies, even if not the specific entity with which a contract is formally executed. Very important. 98. In this scenario, it becomes even more relevant to have a doctrine such as a group of companies in Indian arbitration law. It is already there fully with us. A third party outside the group of companies may transact with a subsidiary due to its faith in the bona fide and commercial know-how of the parent. The third party in question relies upon the stature or presence of the larger parent company, either due to its reputation or personal familiarity with its promoters, directors, or executives. The doctrine itself may also provide greater stimulus for business with new entities that are starting out. Due to the aforementioned peculiarities in Indian business relations, newer companies have significant difficulty in gaining traction. It's a very important reality. One of the means by which such companies can then gain a foothold is by being part of a large, often family-held group of companies. These new entities are then able to feed off the goodwill or relations that the larger group has with the rest of the business world. Given that the connection of the larger group is intrinsic to the way in which business is conducted, arbitration law must acknowledge and address this reality. As I'm done, I want to say, those four heads, along with the safeguard which I have given in writing, are not only comprehensive, well thought out, they take care of the very existence of the concept as also its control with safeguards. There is absolutely no reason your lordship should even dilute it or rewrite what are established things. It would be, in fact, be asked to create some disturbance in an ecosystem where several decisions are happening on this basis. And the Supreme Court alone in the last 3 or 4 judgments many of them authored by the Honorable Chief Justice has taken a view which is clearly
Thank you, Dr.
So I guess.
my lord is asking a question.
It's about at section 11 stage. In short, what do you have to say about that? It has to get into it.
A section 11 stage is a stage which is neutral to any other.
Only prima facie view.
Just give me 2 minutes. Section 11 will not change the view your lordship will otherwise take on other sections. Now, what my lord is concerned about rightly is that if you have a group doctrine which you have not decided fully at that stage, what should you do in 11? At 11, what does the lordship normally do? Is my question to myself. Forget the group case. The lordship has some very complicated problems sometimes. The lordship doesn't have enough time, information at that stage. Your lordship takes a broad prima facie. So somebody comes in and starts talking of group doctrine, and your lordship finds it's a frivolous, false, vexatious argument. Your lordship will give the same reckoning to him. It can't be that because your lordship is hampered at the 11th stage, necessarily you're supposed to be hampered. Therefore, the group doctrine will change.
Okay.
So prima facie remains your lordship.
Prima facie is the principle.
And there's no other way, There's no other way.
Right.
I'm very deeply obliged.
Thank you, Dr.
Very deeply obliged.
I won't take really much time after all the judgments have been read. I'm appearing for an intervener, which is that application.
So this is 56615.
IA 56615. 56615.
Dr. Singh, when you are appearing for an intervener, you have some other proceedings pending before the court? Or?
Yes, actually my matter was referred by your lordships to the arbitrator.
I think Dr. Singh was appearing for Kiloska Brothers, right?
Yes.
Pending.
I am
You have a matter pending.
Yes, it is coming in fact 2 weeks later also.
Mine is the matter which your lordship sent back, which my learned friend has referred that order in ONGC. That's the matter which has gone back to the arbitrators.
Oh, you are
for which a review is pending.
the review. We thought we'll await this for the review. That's why the review is still.
I understand that. I'm not saying anything else to that. I'm not going to argue on any of it. We are not for ONGC, but I am for the other party.
Oh,
R2.
R2, Madas, the Jindal Group.
the Jindal Group.
Yes, which, your lordship allowed the ONGC appeal, sent it back. Now that discovery proceeding is taking place. But Manas, let me start off by saying that though I am in support of the doctrine, group of companies doctrine, Manas, I think we need to tickle it a little. Let me put it that way.
Yes.
Whereas in ordinary law, a litigant is given no choice to choose the court where he wants to go.
Can I take your lordship's leave, Willis?
Yes, sir.
Statutes decide that all litigants dealing with commercial matters go to this court. Suits are filed in civil courts. You can't choose your judge. You can't choose your procedure. That's a given. That's the law of the land. But when you come to arbitration matters, conceptually, the whole proceeding is based on choice. You choose the forum, you choose the applicable law, you choose the seat of arbitration, you choose the arbitrators, and a procedure on which a third arbitrator may be appointed. It's a matter of choice. Choice is at the heart of an arbitration proceeding. This concept, Mullers, has not been recognized. What has been recognized is intention, not choice. Cloro and all subsequent judgments talk of intention of parties. In this context, Mullers, kindly read 2H and 7 with me. To H says party means a party to an arbitration agreement. Nothing more, nothing less. Doesn't talk of a signatory to the arbitration. No, doesn't talk of that. Now come to Mullers. 7. In this part, arbitration agreement means an agreement by the parties, again doesn't talk of signatories, to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. So there must be a defined legal relationship between the parties. It can't be a divorce the parties. That may be contractual, it may not be contractual. But there must be a defined legal relationship that I will supply this material to you under the mother contract. That I will perform this service for you under the mother contract. But there is no defined legal relationship that can be enunciated in the course of a proceeding, Miller. You'll be out of the Cloro doctrine. Because obviously there's a difference between a defined legal relationship and a contractual relationship. The mother agreement says that my affiliate is going to supply you the material. It's part of the mother agreement, part of the contract between Mulats, the parent company, the mother company, as well as the recipient of those of the supply. Supplier is identified. It has a defined legal relationship. It enters it saying that I will be supplying you on such and such, such and such. It's suo motu. There's no contract, but it says that the terms of the supply will be that every 3 quarters, every quarter I'll supply you X amount of the material. It's part of the agreement, Mullahs. Situation is different. Now read Mullah 7.2 with me. An agreement, an arbitration agreement, may be in the form, I'm sorry. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. No problem. Then an arbitration agreement shall be in writing. That's very important. Arbitration agreement shall be in writing. An arbitration agreement is in writing. Kindly, let's mark the words. Is in writing if it is contained in a document signed by the parties. So that creates the problem. An arbitration agreement is an agreement in writing. It is in writing if it is contained in a document signed by the parties. If it is not signed by the parties, it is not in writing. If it is not in writing, it is not an arbitration agreement. If it's not an arbitration agreement, I can't be saddled with the responsibility of having to go through the arbitration process. However, if it is part of a composite whole and there is a defined legal relationship with reference to a mother contract, the doctrine applies. Now we know, mothers, the signed by the parties is a sine qua non. Now that signature of the parties may be on the document itself. It may be by emails and through other forms of communication like telegrams and everything else. That provides the record of the agreement in writing. That may not be mentioned there, but that's what it says. That's what it means. And then an exchange of statements of claim and defense in which the existence of the agreement is alleged by one party or not denied by the other is post the matter going to arbitration.
So according to you, there has to be the existing defined legal relationship.
That's right. That's fundamental, Mullahs. In the absence of that, Mullahs, I give you a lordship just a small example. Supposing, Mullahs, the government of India, Mullahs, floats a tender. When it floats a tender, Mullahs, the conditions of the tender are set out. They also say that if you want to supply, you can have an affiliate. The details of the affiliate have to be mentioned. What the affiliate is to do is also mentioned. And let's be clear, most of these agreements are vetted by lawyers, not overnight. These negotiations go on for months.
So you're saying it's a twin test.
Yes.
One is that there must be a defined legal relationship.
Yes.
Second is that it has to be signed.
Yes.
And that signature need not be in the original formal contract.
Absolutely.
But it can be reflected in what all mentioned in B.
Correct.
Which constitute a record of the agreement.
Correct. That's my limited submission. The reason is simple, Mullahs. And your lordship put it very well, Mullahs, that we are not in a 226 jurisdiction. And when Chloro talks about doing justice between the parties, it's outside of 7. We are not in an equitable jurisdiction framework.
So that justice is really understood in a more restrictive sense in the context of giving business efficacy and business meaning to
That's
it.
fine, Malad. I'm not against that, Malad, but we should not.
Order.
That's right. Your Lordship need to clarify that. That's all that I.
Public law justice.
Yes, Your Lordship needs to clarify that. That's all, Malad. Justice should not mean that the judge feels that no, unless I bring in these parties, even though they are not signatories.
Not equity.
Yes, no equity involved. Choice is paramount because choice will be reflected, brothers. In the communications, choice will be reflected in the relationship, choice will be reflected in the.
Yeah, that.
Actually, clear intention of the party in
That's-
furtherance of the contract.
That's correct. That is correct. The word intention, Millers, has been used all along, chloro onwards.
To give the contract a sense of business efficacy.
Yes, correct, absolutely. But not in the context of Miller's of choice. Not in the context of choice. Therefore, Miller's once chloro was decided, all other judgments followed it. And Miller's, both Justice Surya, as well as Miller's the majority judgment, say that chloro is doubtful.
No, Justice Suryakant doesn't say it is.
Yes, para 20.
What he really says is that there may be some little inconsistencies between the different judgments.
Yes, sir. The para 28 says exactly that. That needs to be clarified.
Yes.
No, in this context, that's what the judge says. Let me just give, I'll read it, Your Lordship need not trouble yourself. Para 28. Yes.
What page is
He says, at the outset, it must be candidly acknowledged that certain inconsistencies do exist in terms of the judgments
Where are you
of the
reading?
court. No,
Where are
no,
you
let me read on. Regarding underlying basis of the group of companies doctrine, for instance, in chloro controls, the court seemed to adopt a contradictory positions. This is not just that, Mullahs. Court seemed to adopt contradictory positions in terms of when a third party may be bound to arbitration agreement. On the one hand, the court emphasized on the intention of parties to include the non-signatory party, but on the other, it went on to add that non-signatory may be added to the arbitration proceedings without their consent in exceptional cases. Thus, it seems that chloro controls places a premium.
Which para was that?
There's 28, Malas. I know your lordships might have missed it.
No, I was just noting, that's all. 28. You are reading the court's order?
Yes,
in the
I'll read it
compilation.
again, Malas. Yes. At the outset,
The
it must be
compilation.
candidly acknowledged that
Your paper of page 920.
Nine twenty.
920.
Can I read it, Malas?
Yes.
At the outset, it must be candidly acknowledged that certain inconsistencies do exist in terms of the judgments of this court regarding the underlying basis for the group of companies doctrine. For instance, in chloro controls, the court seemed to adopt contradictory positions in terms of when a third party may be bound to the arbitration agreement. On the one hand, the court emphasized on the intention of the parties to include the non-signatory party. But on the other, it went on to add that non-signatories may be added to the arbitration proceedings without their consent in exceptional cases. Thus, it seems, 84 of the report. Thus, it seems that while chloro controls places a premium on the intent of parties, it also advocates taking an equity-based approach to discard intent completely, if so required in the interest of justice. And as your lordship knows, the majority says that in any case, chloro need not be followed. But I don't, I'm not taking those extreme positions.
Very reflective of chloro.
Taking those extreme positions, Melissa.
Yes.
What your lordships do, brothers, apply your judicial mind to figure out what the intention of is. The heart of the matter is how I have expressed my choice to be part of the arbitration agreement. That's the heart of the matter. And that choice must be expressed some way or the other through documentation, through my actions, through my relationship, which is defined. And in the absence of that, you can't rope me in.
You got the,
That's the essence of Malat,
thank you, Mr.
of the argument you wanted to end
Yeah, I
there.
think, no. I think you made the heart of the matter. That's the heart. You've gone straight to the heart of the matter.
Yeah, that's really the heart of the matter. That's what your lordships ultimately will have to decide. So my request to your lordships is, now, there's another thing, Malat. Just 2 more minutes, not very long, Malat. I always go by the statute, Malat. The rest comes through judgments of the court. The point is, Malat, in this highly complex world where Malat's big international contracts are drafted and lawyers from across oceans, Malat, look into these contracts. Law firms are 200, 300 lawyers. And Malat, nothing escapes the lawyers. Nothing escapes the lawyers. So, Malat, if something is left out deliberately, you can't invoke some concept of intention. These are not, this is not an ordinary person not knowing about the contract, no idea about the contract. So and as your lordship, as my dear friend rightly pointed out, in any complex contract, there may be entities which may be performing different functions with respect to the contract as a whole. One may not know what the other is doing, in fact. So if the group doctrine can only be applied if you establish that this is a group where there is an affiliate, the affiliate knows what's happening, there is a legal relationship, there is a defining relationship, that's how you move forward. But not on the basis that, look, we think that in this context, justice will be done if all parties are
absolutely
to arbitration.
Equitable principles can't come in. You are saying that when there are large-scale commercial contract with involvement of hard-nosed negotiators, there cannot be a soft solution for such hard-nosed negotiators if they have left out something.
That's right. Now, in the case, that your lordship sent back, not that I'm on the merits, what happened was, a rig was to be set up. Right. Your lordship is aware. The company that set up a rig was an entirely different company. That's Discovery. Entirely different company, except that the promoter was common and some directors were common. Now, what happened was that company gave the contract to a Norwegian company. And the Norwegian company executed the contract.
And they abandoned. They left there.
They left. So, I was roped in on 4 grounds, which your lordships have set out in the order. Kindly see those 4 grounds, if your lordship don't mind.
No, yes.
And the Norwegian company is not brought in. This will happen, There's no mother corporation here, There's no relationship of that sort. There is no affiliate here. But if you bring in the equitable principle, you're bound to include everyone.
That in your case, ultimately, you will have to argue in the arbitration.
I agree. I'm not arguing here, All that I'm saying is, then, my learned friend pointed about piercing the corporate veil. May I just give a lordship one judgment? This is very important. 2014, 9 SEC 407. Then I've done, I made my point. 2014, 9 SEC 407. Yes. Para 66. Actually, 70 is what we'll be. Why do it? We've got sort of time. The solicitor has to argue. I've already.
70 and 71.
70, 71, I think.
66.
So that's at page 439, paragraph 70. Have you airdropped it?
Yeah.
Airdropped it.
Yes.
Yes. May I read it, Manas?
Yes.
The doctrine of piercing of corporate veil stands as an exception to the principle that a company is a legal entity, separate and distinct from shareholders with its own legal rights and obligations. It seeks to disregard the separate personality of the company and attribute the acts of the company to those who are allegedly in direct control of its operation. The starting point of this doctrine is Solomon versus Solomon. Let's leave that out. Now, 71. In recent times, the law has been crystallized around the 6 principles formulated by Justice Banbi in Ben Hashem. The 6 principles are: ownership and control of a company were not enough to justify piercing the corporate veil. 2, the court cannot pierce the corporate veil even in the absence of third-party interest in the company, merely because it thought to be necessary in the interest of justice. That's the equitable principle. The corporate veil can be pierced only if there is some impropriety. As your lordship said, some Benami, some shell companies being set up, well, certainly you'll apply the doctrine. The impropriety in question must be linked to the use of the company structure to avoid or conceal liability. 5, to justify piercing the corporate veil, there must be both control of the company by the wrongdoers and impropriety, that is, use or misuse of the company by them as a device or facade to conceal their wrongdoing. And 6, the company may be a facade, even though it was not originally incorporated with any deceptive intent, provided that it is being used for the purpose of deception at the time of the relevant transactions. The court would, however, pierce the corporate veil only so far as it was necessary in order to provide a remedy for the particular wrong which those controlling the company had done. Then, minutes 74. 74 is the last. Let's leave 73. Thus, on relying upon the aforesaid decisions, the doctrine of piercing the corporate veil allows the court to disregard the separate legal personality of a company and impose liability upon the persons exercising real control over the company. Apply these principles to the doctrine, no issue. Go beyond also, no issue. But not beyond the definition. Not beyond 7 and the intent of 7.
Thank you.
What? Then the other thing, this is an article by the Boston University Law School article, where they say that the doctrine has been rejected in the UK, in the United States. I'll just hand it over to you. In the United States, in the UK. So the doctrine is really in
follow UNCITRAL model law. I am not.
Swiss courts, just see paragraph 34, page 34 at the bottom. I just so that.
This guy is celebrated as a professor. He is vice president of CIA.
He is a professor, one of the renowned arbitration authorities globally. He's a professor of law, general editor, arbitration.
Look at his first sentence in the article.
Yes. Like consummated romance, arbitration rests on consent. Now let's see page 34. Page 34 only. Outside of France, few legal systems welcome the group companies doctrine. The English decision in Peterson Farms case was clear in its disapproval, stating that an arbitral tribunal's approach in applying the doctrine was seriously flawed, and concluding that where an arbitration agreement or a contract in which it is contained is subject to English law, the ICC Arbitration Tribunal has no jurisdiction to apply the group of girls doctrine. Similarly, Swiss courts and arbitrators in Switzerland have generally rejected joinder based on group companies doctrine, and have courts in the United States. So it's not something that is universally applied. But we have to interpret our section 7, and I've made my submission. Thank you very much.
Thank you, Mr. Yes, Mr. Elizabeth.
Well, lawsuits are till 320.
Yes.
It's not,
325, 327.
Okay. I need 1 hour. I have prepared myself. Can I take it on Tuesday? I told your lordships are keeping it on Tuesday.
I'll take only 10 or 15 minutes, subject to your lordship's kind convenience.
We can complete your argument. Yes, we'll hear you on Tuesday, Mr.
Deeply applied.
And then Mr. Rai in the.
Prepared a short note.
Give us a note now.
Well, I can be given, my lord, after, on
Complete it.
Tuesday.
Just tell us like Mr. Sybil
What are your-
formulated,
what
just
are your-
formulate
Yes,
your
ma'am.
points.
I'll formulate it and give it.
You are done. Just
Yeah.
telling him.
That your lordship may excuse me on that.
Yes, Mr. Bell, thanks.
Thank you.
Lord, if I may,
Thank you, Mr. Bell.
my lord, what I have attempted to do is set out the statutory framework, set out what are the international best practices in relation to bringing in a non-signatory into an arbitration, and then see how these best practices fit within the Indian statutory framework. If I may straight away draw your lordship's kind attention to paragraph 4 of my note at page 2. Paragraph 4, the key takeaways from section 2(1)H and section 7. My lord, your lordship has read these provisions over and over again. My lord, 2(1)H defines a party to mean a party to an arbitration agreement which is necessarily wider than signatory. If the intention was to restrict it only to signatories, that language would have been used in 2(1)H.
What is the next?
Sorry, ma'am.
The next point?
Going to the language of 7(1), 7(1) again says that parties, an agreement by the parties to submit to arbitration all or certain disputes. It doesn't use the language signatories. Now, 7(3) then says that an arbitration agreement shall be in writing. Now, what this rules out is an oral agreement. It does not rule out an implied written agreement. That's the point I'm seeking to make, my lord. 7(3) rules out an oral agreement.
What is the contradiction in terms? Implied written agreement?
My lord, if there is no direct agreement between the parties, but an agreement can be inferred by reading the correspondence between the parties. If a common intention can be inferred by reading the between parties, then that, in my respectful submission, would be an implied written agreement.
That falls under P3.
Therefore, my lord, today, now when 7(3) in my respectful submission does not rule out implied agreements altogether. All it rules out is oral agreements. It is still open to court to infer an arbitration agreement or consent of a non-signatory to participate in an arbitration in the manner provided in section 7(4). Now, when your lordship looks at section 7(4), section 7(4)(a) deals with signatories, that is a party who has signed the agreement. 7(4)(b) and 7(4)(c) deal with situations of non-signatories because there is no signed document. Yes. These are situations where from the correspondence available, from a written document available, an agreement can be inferred. And if an agreement can be inferred, that would fall within the implied consent theory, which is what in my respectful submission would be applicable as per the Indian statute. The only, the sequitur therefore is that from documents available, not oral evidence, not any assertion of oral agreement, if it is clear that a non-signatory agrees to be bound by an arbitration agreement, then arbitration can proceed against a non-signatory because a non-signatory would then be a party. Because all that you require to be a party is you need to fall within the ambit of 7, it may be 7(4)(b), it may be 7(4)(c). Okay. The next category, my lords, is claiming through or under, which has been brought in under section 8 and section 45. In my respectful submission, this would not cover a scenario relating to group of companies. What this would refer to is where the right of the third party is derived from a party to the arbitration agreement. These would be situations of assignees, situations of legal representatives, and possibly even derivative action suits. Well, therefore, what I have done in the next section is looked at international best practices. I have looked at the US, I have looked at Singapore, and I have looked at France. I have referred to the various tests that have been applied there. I have footnoted the relevant case laws that are part of my compilation. I have also looked at the tests that have been adopted by various authors. I know if I go into all of that, I don't have the time for that, but I have set out exhaustively what these tests are with references to the footnotes in section C of my note.
Its application.
In section D, my lords, I set out, my lords, what in my respectful submission would be the test that would best fit within the Indian statutory framework. Now, under the Indian statute, to be referred to arbitration, it is a sine qua non that you have to be a party. Now, you can be a party in two different ways. Firstly, based on implied consent. Such implied consent must be in writing, must be borne out by documents in the form set out under 7.4b, or it can fall under 7.4c, that is post-arbitration. This is the only manner in which implied consent can be gathered, and if there is implied consent, then a non-signatory can also be a party to an arbitration agreement. Now, in this regard, my lords, in my respectful submission, this would encompass the group of companies doctrine in a more limited manner. If this test is to be applied, the paragraph 73 test of mother agreement, progeny agreement, etc., all of that would not be part of the statutory framework. But all that the court needs to look into is there express or implied consent from a non-signatory to be bound by the arbitration agreement. If the answer is yes, then a non-signatory would also be a party to the arbitration agreement and would hence be bound by the arbitration agreement. That would be the first category, that is non-signatories who are parties because they expressly or impliedly consent to being bound by the arbitration agreement. The second category, my lords, that I've set out at page 11 is where a third party is deemed to be a party by operation of law. This would be a situation pertaining to piercing the corporate veil. So if A and B are parties to an arbitration agreement, and you lift the corporate veil of B and you find C and D, then by way of a legal fiction that has been recognized by this Honorable Court in multiple cases, C and D are part of the same legal entity as B and therefore are deemed to be a party. The bottom line, my lords, is that ultimately to be referred to arbitration, you have to be a party. So you can be a party either by consent, either express or implied, so long as that consent is derived from a document in writing, or it can be by operation of law, that is piercing the corporate veil. The third category would be based on the expression through or under, claiming through or under. This would cover categories not covered in categories 1 and 2, but would be situations where a third party derives its right from a party to the arbitration agreement. This could be a case of either assignment or a case of a legal representative that is also spelled out in section 40. It could even cover a situation of a derivative action suit. The reason I say could is there is still a controversy on whether you have to go exclusively to the NCLT for derivative action suit. Therefore, my lords, if this test is set out, in my respectful submission, it would be beneficial for a number of reasons. One, it would simplify the chloro control test. All that a court will have to look into is whether there is implied or express consent from the documents available on record. That's all the test would be. Secondly, it would also, my lords, provide some, it would help reconcile, my lords, the point raised by His Lordship Justice Suryakant at paragraph 84 at Cox and Kings, where on one hand he says that it's an intention-based test, and on the other hand he says that chloro control recognizes that in exceptional circumstances, even when there is no intention, a third-party signatory can be made a party. This three-step analysis, my lords, would also help reconcile this paragraph of His Lordship Justice Suryakant's judgment, because it would mean that by default, consent would be required. It would only be in exceptional situations of piercing the corporate veil, where without consent, a non-signatory can be referred, and that too by operation of law. Ultimately, my lords, there is also one important supporting policy consideration when your lordship looks at this issue. That is one-stop arbitration, which your lordship has recognized in Ayaswamy's case. Now, if you look at the chloro control situation, and assuming that there was
the same point that there should not be a fragmentation of.
I brought on, my lords. If there are going to be multiple disputes, one between the parent and one between the subsidiaries on the same cause of action, there is a possibility of different fora reaching opposing conclusions. Hence, this policy consideration, my lords, is also something that, in my respectful submission, would be a relevant consideration for your lordships to take into account. Going to the, I will not take more than 1 minute, just going to the specific fact of my case, and the reason I'm bringing that up, I'm in item 501.B, this 501.2, this is a specific case of implied consent because this is an agreement between, there is an agreement between the financier and the borrower. There is an agreement between the financier and the guarantor, and the guarantee agreement does not contain an arbitration clause. The main agreement contains an arbitration clause. The guarantee agreement contains a provision saying that the guarantor waives any objections to jurisdiction so long as the arbitration is commenced so long as the proceedings are before a court or tribunal in Chennai. And he irrevocably undertakes to submit to the jurisdiction of any court or tribunal in Chennai. This, in my respectful submission, would be a textbook example of implied consent. Therefore, my respectful submission, my lord, is your lordship may consider adopting this simpler test that would cover the chloro control test, but in a more limited form, and would make it more easier for application going forward. But I'm passed on the compilation, my lords. I'm deeply obliged, my lords, for the opportunity given.
Thank you, Mr. Krishna. Thank you, Mr.
Very much.
5 minutes, he said.
5 minutes you want to?
Just 10 minutes, Manoj, 10 minutes.
All
There's
right.
only one.
Just state 10 points.
Sorry, there's only one more aspect. Implied consent would also be something wider than group of companies because it need not be a group of companies. It can even be a promoter and a small company run by him.
All right.
That's great.
Which matter are you appearing in?
Manoj, I'm in the intervention 501.
501.
Manoj.
And who are you appearing for?
Intervention.
Yes.
Manoj, intervention application 58168.
5-1.
58168.
Of?
2023. Manoj, I've just drawn my lord's attention to the facts of my case. Why it is important is shows a classic example why group companies doctrine must apply. What has happened in my case is that I entered into an agreement with a subsidiary and the subsidiary fails to execute the agreement. The parent company, which is a Chinese company, steps in and says, look, don't worry, we will have it executed. They float another subsidiary and they are the ones who are licensors to the goods and their inventory is lying with me today for which I have to resell. So when the subsidiary fails, somebody runs away or the company gets closed, they float another company. They themselves don't come to India and do the matter. They float another company in India and they say, now you deal with this company and this company will help you do this thing. So this is a classic case where my lords will have to go into the equities of the entire equation and then find out whether they should be made party to the agreement or not. In fact, not one classic way of undertaking business today, which I have come across, is how Chinese companies are selling solar modules in India. What they are doing is they are floating subsidiaries in Hong Kong. They are mainland companies based in mainland China. They are floating companies in Hong Kong, which is just one-room offices. And these companies, shell companies, enter into agreements with Indian companies for supplying of solar modules. If there's an issue or dispute regarding the quality of the solar modules, then I'll end up suing only that Hong Kong company because this is what I've entered into agreement with, which is just a one-room company in Hong Kong. And I will face difficulties in executing this agreement in mainland China because the enforcement of awards in China is slightly disputed, or even SIAC awards. So that is the way the impact of Indian courts or the effectiveness of the remedy which I should have will be defeated by the entire design which is undertaken. So, my lords, in order, my case, my lords, submission is just make my submissions, what I need to make submissions, my lords. Number one is, my lords, I support the case of Mr. Hero Advani that yes, doctrine of companies must get expansive interpretation. Number two, my lords, I dispute the position of Dr. Singhvi that only in mother agreement cases they should be applicable. Control was just a fact situation where group companies doctrine was applied, but chloro control leaves room and reiterates that there are other equitable principles which will come in situations where the courts have to provide effective remedy to the parties. What are the situations other than group companies doctrine which can be applicable, my lords? One is the group companies doctrine. Second is alter ego. Third is what Mr. Kapil Sibal mentioned, which is corporate veil. My submission is the moment you bring in corporate veil and you bring in an ounce of equity, other principles automatically get drawn up. Because they all have the same source. One way to put it would be that group companies doctrine is the umbrella doctrine, and within which US courts recognize other principles like equitable estoppel, agency, ratification, alter ego, corporate veil, and group company. That could be one way to look at it. Other way to look at it is that equitable principles are there broad, and these are the subheads. What US courts said is recently Supreme Court also, yes, they did not recognize the group companies doctrine, but they use these other agency contract-based arguments to reach the same conclusion. So I'll try and place that, my lords, on Tuesday. I'll take 10 minutes, my lords. I'll try to place all those statements on record.
Note.
And I'll ensure, my lords.
Prepare a note and then you read it out of it.
Absolutely, my lords. And on section 7 also I have an argument to make. I'll try and satisfy.
Email everything in a soft form, soft copies to the court master.
I'll do that, my lords. I'm obliged.
Mr. Solicitor, thereafter we'll hear you on Tuesday.
Please, sir.